Welcome, everybody. We at CLPR are excited to welcome you to the US-India Comparative Constitutional Law 2.0 series. CLPR is a not-for-profit trust dedicated to making the Constitution work for everyone through law and policy research, social and governance interventions, and strategic impact litigation. This project is in furtherance of our efforts under our Constitutional Culture Initiative. The initiative is aimed at creating public awareness and enabling active engagement with India's constitutional tradition to build a popular constitutional culture in the country. Over the years, the initiative has expanded in scope to include digital resources and archival material on Indian constitutional history and practice, posted on our website constitutionofindia.net, public events, workshops, and conferences. This is the first of a series of 4 workshops on US-India comparative constitutional law themes and issues. The purpose of this project is to help students understand and appreciate the constitutional traditions of India and US. We're happy to have partnered with Tamil Nadu Dr. Ambedkar Law University, Chennai for our first workshop, and we are grateful to the US Consulate General, Chennai for their support. Now I will hand it over to Senior Advocate Jenna Kothari, the Executive Director of CLPR.
Hello, everyone, and thank you for joining us bright and early on a Saturday morning at 9 to discuss constitutional law in a comparative context. So just wanted to say, first of all, thank you to everyone for joining, especially the students, because really this event and this day is really for an interaction with the students. Before we start, I'd like to give a brief introduction about CLPR and what CLPR does. I'm not sure if all of you are familiar with our work and our organization. The Center for Law and Policy Research is based in Bangalore, but we work all over the country, and one of our big initiatives is working on developing a constitutional culture in our daily lives, and how do we internalize the values of our constitution. We also work on other areas such as gender and sexuality. We work on transgender rights. We work on urban governance. We work on disability rights. And we also work on discrimination law. More about that can be found on our website. But for the moment, I'll focus a little bit on some of our work around building a constitutional culture. So some of the things we do to ensure that we're able to all engage with the Constitution, whether we are lawyers or not, whether we're students from any discipline or from any walk, all walks of life, is to make materials around the Constitution easily accessible and easily available to everyone. So one of the things, one of our initiatives is our constitutionofindia.net website, where historical materials around the Constitution, Constituent Assembly debates are easily available, searchable, so that anyone who wants to use them can just go there and get it. Materials around Constituent Assembly members, their biographies, some of the important Constituent Assembly debates are all available. So I would really urge all of you who are interested to check out the website. It's constitutionofindia.net. The other things we do, a lot of other fun events to make us more familiar with our constitution and constitutional history, is a quiz, an annual quiz that we have every year called Conquest. And I'm not sure if some of you have participated, but we have more than 200 teams participating every year. Of course, this year was an online quiz, but usually we have a physical quiz. And the quiz is around the Constitution and Constitution history. So that is one event. What we recently did for Independence Day this year is that we brought out some beautifully designed t-shirts with the preamble, with the text of our preamble. And this was also a great way to speak about the preamble to non-lawyers or to non-law students, and to begin conversations around what values the preamble and our constitution holds. So many of these things are and activities are really done to enable us to engage with the Constitution. We have another initiative which one of our sister organizations has started called the Supreme Court Observer. The Supreme Court Observer website is also something I would like you to all look at whenever you can. In the Supreme Court Observer portal, we look at important cases of public importance that the Supreme Court has decided, and we simplify the judgments. We make the decisions more accessible in simple, plain English formats. We have some of the materials available, the pleadings, etc., so that anyone who really wants to find out, for example, if we want to read about the Shabrimala case, now the judgment itself can be quite daunting because there are so many different judgments, and each of them are like about 200 pages long. So for a lay person, or even for perhaps for a student, to get a simplified a simple version of it may be a way to kind of really understand the judgment and then go into it. Another initiative we have done is the NCS, which is the National Constitution Society. We have started a network with some universities where we encourage students to form national constitution societies within their colleges. And we give any assistance they might need for ideas or resources to have small events in their universities. It could be a film screening where you follow it up with a discussion. It could be a panel talk. It could be a quiz. It could be just a book reading, but really to encourage students to discuss the Constitution or constitutional values. I'm not sure if the Ambedkar Law University has an NCS chapter, but if not, we would be very happy to help kickstart that if some of the students are interested. So I'll stop there. And really today's the discussion today and tomorrow is a great opportunity to have a comparative constitutional conversations with some of you students in Chennai and some of the students from the US law colleges. And we have a set of readings that we've shared with you all. And we have some fantastic team members from CLPR who will take you through the readings. We have some great faculty who are also joining us to respond to some of these sessions. So I really hope that all of you throw yourself in. Feel free to raise questions about any of the readings that you may not have understood. This is a great opportunity to do it. I think in many of our law school experiences, we didn't have the chance to do some of this comparative reading and discussion. So I think it can be a really exciting 2 days. So I'm looking forward to it as much as you all. Thank you.
Thank you, Jenna. We also have with us here today Ms. Anli Seshadri and Usha Davdur from the US Consulate General Chennai office. Ms. Anli Seshadri is the Public Affairs Officer at the US Consulate General in Chennai, India. She previously held public diplomacy assignments in Bangkok, Thailand, Toronto, Canada, New Delhi, as well as Washington, DC. She has lived and worked across Southeast Asia and was a Boren Scholar in Hanoi, Vietnam. Thank you, Ms. Seshadri, for joining us today. The floor is yours. I think you're on mute. You may have to unmute yourself.
In my bag, so don't mind me if I start to scratch my arm. Good morning, everyone. This is a long-awaited day. We have been working on this U.S.-India constitutional law project for some time. Obviously, it was going to look a little different before COVID-19, but I'm just thrilled that we were able to make some changes and come together and then do these wonderful virtual exchanges with really some of the best law schools in the United States. I know you guys are going to be up tonight talking to some students in California, which is going to be a really exciting session. We have a number of diplomats who are lawyers, and I have one of them lined up to be with you tonight named Sash Lewis, so he's looking forward to that. About 10% of everyone in the Foreign Service has a law background. I don't know if it works that way here, but we have some great resources at the consulate. So I wanted to thank our partners from Tamil Nadu, Dr. Ambedkar Law University. Dr. Ranjit is our alumnus, distinguished alumnus of an exchange program to the United States, Vice Chancellor of the university, and to all of you for making the time on a weekend. And really, this is all the good work of Usha Davalor, who's championed this project. So we thank you for bringing us together. I was thinking about the US Constitution, and the first time I saw it, I don't know if you guys house your Constitution in a visible place. Do you? You can see it? Okay. Have you ever been to Washington, D.C.? Anybody? Yeah. So we have, in Washington, we have the Smithsonian museums. It's quite beautiful. They're all free and open to the public. And we have the National Archives as one of them. And it's this very impressive building, and there's just big stairs. And you go up the stairs, and they have the Constitution under glass. And every night it gets lowered under the building for safekeeping, sort of in a vault. And every morning when the building opens, it sort of emerges out. And the line snakes around the block, and you go up the stairs and you peer into this glass case and you see the Constitution. So I remember the first time I saw it, and how exciting it was, and what an important document it is for our country. And of course, the same is true in India. So it's really fitting, I think, that we're opening the program here at the Dr. Ambedkar Law University, because obviously Dr. Ambedkar played a key role in making India's constitution. And he was also a student of the American Constitution when he studied at Columbia University in New York. And I hope that when you talk to the Americans, you can educate them a little bit about Dr. Ambedkar. I'm not sure how much they know, but these exchanges are always two-way, right? We know that Dr. Ambedkar provided constitutional guarantees and protections for a wide range of civil liberties, including freedom of religion, the abolition of untouchability, and outlawed all forms of discrimination. And we know that he argued for extensive economic and social rights for women. And he's celebrated for providing an inspiring preamble to the Constitution that ensured justice, social, economic, and political liberty, equality, and fraternity. I've also been reading a little bit about Dr. B.N. Rao, who I understand was from Chennai, who was your constitutional advisor, and understand that he spent some time in the United States as well and met President Truman and met Justice Frankfurter in the US and learned a little bit about our Constitution at the time when he was embarking on the Indian Constitution. So those are some really interesting connections. So why is the consulate doing this? Well, we have always promoted democracy, and I think even more so now under this administration, with the Biden administration, they've actually elevated the conversation, and they've asked embassies and consulates to really do more to have these discussions about the importance of democratic governance. So one example of that is something that we're starting to work on now, which is called the Summit of Democracies. I don't know if you guys have heard about this, but President Biden has asked all the world leaders of democratic nations to come together. So this year it's going to be virtual, December 9th and 10th. And then next year it's going to be an in-person summit. And they're going to really discuss, their successes. They're going to build collaboration. They're going to speak honestly about challenges facing democracy so that we can collectively strengthen the foundation for democratic renewal. We know that democracies are, if you look globally, they're declining. Authoritarianism is rising. And so we're trying to get ahead of that and sort of strengthen the foundation for democracies. So the summit will have three goals. One is defending against authoritarianism. One is fighting corruption. And the other one is promoting respect for human rights. So right now we're having these interesting discussions about like which sessions will make the most sense for South Asia, for India, and the US. So for example, we're looking at maybe doing a virtual session on internet freedom. So it's exciting. And we've really been through in our country a lot in the past few years, examining our own flaws in our democratic process. And re-examining the Constitution and whether we're keeping up with the promises of the Constitution. And so our approach, as Secretary of State Blinken says, is really to just be honest and talk about our flaws. And so I hope you'll hear that from the students in the US. They're probably very outspoken about some of the things happening in the US with Black Lives Matter, a lot of the other issues that are going on, affirmative action, I believe is tonight's discussion. So protecting minority rights, is a big conversation. So that should be an interesting conversation for you. And I think that, we just think about what Winston Churchill said about democracy, which is, it's the worst form of government except for all the other kinds. So really excited about the project, excited that you guys are going to kick it off, excited to work with CPLR and all the other great universities in South India. And I wish you the best of luck for this evening and for the remainder of the project. So thank you very much.
Thank you, Mrs. Shadri. I think we will take a break for about 10 minutes now, and we will reconvene for our first session on constitutional founding. We'll start our first session on constitutional founding. Before I start the session, just a few points. If any student wants to speak, or you can just use the raise your hand option or type in your question in the chat box, and we'll take a look at it. And second, please mute yourselves. I've muted all of you, but just in case it gets unmuted, request you please mute yourselves when you're not speaking, and turn on your videos when you're speaking, whichever student is logging in online. Then we'll start the session. Kalyani, could you share the slides, please?
Yeah, doing that. I hope you can see my screen.
Yeah, we can see your screen. Yeah.
Great.
All right. So I'll start the session. So in this session, we're going to look at how the two constitutions came into being in US and India. So first, as Ms. Seshadri mentioned, the US Constitution has had an impact on the Indian Constitution, both in the constitution making process and in how it's practiced. And even Nehru, when he was introducing the objectives resolution in the Constituent Assembly, had mentioned that, and I quote, "I think also of the various constituent assemblies that have gone before and of what took place at the making of the great American nation when the fathers of that nation met and fashioned out a constitution which has stood the test of so many years, more than a century and a half, and of the great nation which has resulted, which has been built up on the basis of that constitution." Jawaharlal Nehru, taking inspiration from the American Constitution, wanted to take into account the influences of that in the constitution making process itself. And if you see, many constitutional provisions in India have been borrowed or been inspired by the American Constitution, for instance, the judicial review framework. In fact, an interesting story, to draw from what Ms. Seshadri had mentioned, B.N. Rao had actually, who's the constituent advisor to the Constituent Assembly, wanted to include due process in Article 21. But after his visit to the US, when he met Justice Frankfurter had actually warned him against including due process. And he had said that due process is actually a very undemocratic principle because it gives the judiciary too much power to interfere in matters of the legislature. And it also casts an undue burden on the judiciary. So interestingly, however, so B.N. Rao had dropped the idea of adding due process in Article 21, but courts in India have gone back to American jurisprudence and included due process in many of their judgments. So it's interesting to see how American constitutional practice has also influenced the Indian constitutional practice. Having spoken so much about the American Constitution, let's now try to understand how this Constitution was formed. So in 1775, just when the American Revolutionary War was started, it's important to note that America was basically a loose group of 13 colonies of the British, and the war was declared against the British to gain independence for these colonies. And on July 4th, 1776, after the war was declared, the American colonies came together to declare independence from the British. And this document, this Declaration of Independence, had two very important clauses. First, all men are created equal. And second, that people have the right to choose their government. This, interestingly, this Declaration of Independence has a significant influence on one of the historical documents that we will come across in the Indian constitution making process as well. I just thought I'd flag it off here so students can pay attention to that similarity. So after this Declaration of Independence was adopted in Philadelphia in 1776, the colonies were wondering how to govern themselves. So they came up with something known as the Articles of Confederation to govern themselves at the national level, and the state constitutions, which would govern them at each colony level. So the Articles of Confederation were actually drafted by a 13-member committee and was adopted on November 15th, 1777. The Articles of Confederation basically forms a national government. It provides for a legislature, but no executive, no judiciary. It does not give the national government any power to tax or regulate commerce between the various colonies. And it cannot ask them to join, it cannot invite members from the colonies to join their army troops. It cannot raise money from the colonies. So it had a very limited scope. Now, in 1783, with the end of the American Revolution, they felt, leaders like Hamilton felt that there was a need to have a more strong national government and basically amend Articles of Confederation, because the national government under the Articles of Confederation had very limited powers and couldn't do much without the ability to raise funds. So in 1786, Hamilton proposed that they have a new constitution, and the Confederation Congress in February 1787 endorsed this view, and they requested the 13 states to send delegations to a meeting in Philadelphia. This is popularly known as the Constitutional Convention at Philadelphia. This started on May 25th, 1787, with about 55 delegates from the 12 colonies. Rhode Island was the only colony that did not send a representative. George Washington was unanimously elected as the president of this convention. So the scope of this convention, what started off as was to amend the Articles of Confederation to include a more strong national government with more powers. But it sort of took a new form during the deliberations, and they in fact chose to elect a new form of government itself with 3 distinct branches of the legislative, executive, and judiciary. And these 3 branches there would be a system of checks and balances to ensure that these 3 branches are operating within their scope. So in September, after about 4 months, September 1787, after all the deliberations and agreement to have this form of government in place, 5 members, Alexander Hamilton, James Madison, William Samuel Johnson, Morris, and Rufus King drafted the American Constitution. And now that this Constitution was drafted in September 1787, the process doesn't end there, because they needed the Constitution to be ratified by the 13 colonies. So the ratification process started in December 1787. To convince colonies and people to ratify the Constitution, Madison and Hamilton wrote a series of 85 essays, commonly called the Federalist Papers. And these were essays written to persuade people to ratify the constitution that was adopted in September 1787. So the ratification process took about 3 years, with the last, with Rhode Island ratifying the constitution in 1790. Now, as I mentioned, the constitution, the scope of it was fairly limited. It was a very short document with about 7 articles. It laid down the 3 organs of the state, which was the legislature, the executive, and the judiciary. And what it also did was laid down the amendment process, stated that what the relationship between the states would be, that the constitution was the supreme law of the land, and what is the ratification process. It didn't go beyond that. It did include civil liberties. It didn't include rights, or the fundamental rights as we know in our constitution. This was something that came afterwards. So in 1789, James Madison, who was the representative at the newly established House of Representatives, and he introduced 19 amendments to the Constitution that was adopted in 1787. Out of these 19 amendments, only 10 amendments were finally ratified by all states, and these commonly came to be known as the Bill of Rights. This Bill of Rights included the right to freedom of speech, religion, to assemble, to carry arms, and these Bill of Rights became a part of the Constitution in 1791. Along with the Bill of Rights, the Constitution up until today has had about 27 amendments, because the amendment process is fairly rigorous. And you will see, as compared to India, which has had about 104 amendments so far in the Constitution, it's interesting to see how a constitution of longer duration has had only 27 amendments. Now, I will go to show you, now we will see how the Indian Constitution came into being. And we have a small video that we had produced, an animated video that takes us through the story of how our Constitution came into being. Kalyani, I don't think we can hear the sound.
Sure, I'll just ensure you can. I think you should be able to hear it now.
Yes.
We the people, having solemnly resolved to constitute India, battled the British for over a century on the streets and in the courts and assemblies to realize our collective desire for freedom from colonial authoritarian rule. This found an early voice in 1895 with the Swaraj Bill, which demanded a dominion state with equality for all and freedom of speech. In 1928, Motilal Nehru's report went further to call for self-governance and minority rights. However, both demands fell on deaf ears. So on 26 January 1930, the Indian National Congress declared Purna Swaraj, or complete independence, discarding the demand for dominion status. A year later, at its Karachi session in 1931, the INC demanded comprehensive social and economic rights. Sensing imminent change, M.N. Roy proposed a constitution drafted by a Constituent Assembly of Indians, by Indians and for Indians. The INC embraced this view, and after years of relentless negotiations with the British, a Constituent Assembly was created in 1946. Nearly 300 members, representing all shades of political opinion, diverse religions, ethnicity, and from all over India, met in the plenary assembly and subcommittees across 3 years to draft India's constitution. They made deliberate and radical constitutional choices to first, transition India from a colonial authoritarian state to a constitutional democratic republic with adult franchise and representative legislatures and independent courts to maintain the rule of law. Second, to transform a traditional society built on caste hierarchy and patriarchy into a modern egalitarian society based on every individual's dignity and fraternal relations between them all. Third, usher in a multi-religious secular democracy by assuring individual freedom of religion and keeping the state away from organized religion. And lastly, to restructure a feudal economy based on concentrated or inherited wealth and large landholdings by distributing land and other economic resources and ensuring social and economic welfare. Finally, this new Constitution Republic was born on 26th January 1950. 7 decades later, our Constitutional Republic needs you to be a constitution defender, to preserve, protect, and realize the progressive constitutional dream to build a new India.
Thank you for that. Do any of the students have any questions? Don't have any questions in the chat either. Okay, so I'm assuming that there are no questions. So we'll move to the discussion.
Maybe, Meenakshi, we can just wait a minute
Sure.
and ask students if they can raise a few questions and give some time.
Sure, absolutely.
Do you want to remove the presentation? Yeah. So can I mean, did any of the students find similarities or dissimilarities in some of the motivations, both in the US and Indian constitution making? Were you familiar with how the US Constitution was drafted and brought into enactment, or was this perhaps the first time that you became familiar with the US Constitution drafting process? And this is just really a way for us to discuss it. So please feel free and, raise your hand and just kind of give your inputs or any questions that you had. Sorry, can't hear you. Can you be louder?
Can you hear me now?
Yeah, better.
I'm just asking the students in this room whether they have any questions on the pattern of the founding style of the Constitution between United States and India.
Yes.
Both of them are on a doubtless platform, because there was a very good clarity on Meenakshi's presentation on basic founding of Indian Constitution. Still, we would love to know more about the challenges which both the countries have faced in the founding pattern, especially because we know that we are comparing between the largest and the oldest democracy. So we'd be glad to know if there were any specific challenges which were similar to both the
Yeah, and I think it would, of course, we can discuss it and do something maybe at a later stage. But really, how the U.S. The manner in which the states and colonies were kind of brought into adopting the constitution, and also the Indian Constituent Assembly debates and the challenges, both the kind of processes would be really interesting to compare, I feel. If we could kind of put that in some, maybe if the university wants to have another discussion around that, or a couple of classes around that, that would be great. But Meenakshi, would you like to respond to that?
Yeah. So essentially what we thought we could start off with is to actually ask students about the process itself, to see if they were democratic in nature in both countries. And then I thought I will highlight some of the challenges in ensuring that the process was democratic. So if the students want to take a stab at answering that question, then probably we'll start with that, and then I will respond directly to Professor Ranjit's question. Yeah.
And we'd really like some of the students to just say whatever they feel like, really. This is not a test or anything. It's just a way for us to kind of be curious about the democratic processes. So please just feel free. What did you think about the two processes? Were you surprised that they were quite similar? Did you expect that they would be very different?
I'm audible.
Yes.
Yes.
I just had one major doubt. Such a big country, when they got independent, how did they come up with just 7 articles initially?
Right. So just to answer your question very quickly, in short, is that in the US, even until now, you have two levels of administration when you look at it constitutionally. First is you have the national constitution, and then you have state constitutions. So even then, back then, with the Articles of Confederation, you had the Articles of Confederation governing the national government, and you had multiple state constitutions governing each individual colony. And some of these, even today, if you look at probably Alabama state constitution, it runs to about 600 pages. So they have more details in those. And at the national level, they stuck to a very small, limited scope. And that's in fact very interesting to note that it also ties in with the federal structure adopted in the US versus the federalism that's adopted in India, which is the level of state central control over state affairs. So if you see in the US, there is a strict division between the state and the center, and you see a very rigid federal structure that is adopted, as opposed to India, where it's often stated that we have a federalism with a unitary bias, where we have a strong center, and therefore we needed a constitution at the central level that is elaborate and details out a lot of things. And another reason for our detail and our length also comes from the fact that we cover a larger number of topics, which includes fundamental rights, directive principles of state policy, and we also have a lot of administrative details and rules, which we took from the Government of India Act of 1935. So I hope that answers your question.
It does, it definitely does. Am I audible?
Yes, I can hear you.
Yeah, so I had like a follow-up question to that.
Yes,
Constitution was discussed for more than like 3 years.
that's right.
Was a similar assembly discussion there in the US as well? And
Yes.
then the difference in time, like for the 3 years in India, what was in place? Like how did the citizens get their rights in that time?
Yeah. So it is interesting. So it depends on how you want to look at the constitution making process in the US. Do you want to look at it only as the Philadelphia Convention, which took place for 4 months? Or do you want to start with 1777, when the Articles of Confederation was adopted, up until 1790, when it was ratified by all states? If you take into account the entire constitution making process, it went on for a good 13 years. But even then, if you look at the Philadelphia Convention for 4 months, yes, there was discussions. But if you look at the Indian Constituent Assembly, which sat for about 2 years and 11 months, is basically the amount of deliberation that was involved. As you knew, you would have seen in your readings as well, is that we had one Constituent Assembly that was broken up into several committees. So you had plenary assembly discussions, then you broke down into committees. Committees did their had their discussions, came up with their recommendations. These recommendations were again presented to the Constituent Assembly. Then there were deliberations on that, amendments made to the draft constitution. It was a fairly deliberative process that the Constituent Assembly adopted, as opposed to maybe what happened. Yes, there was deliberation in the Philadelphia Convention for about 4 months, but the extent of back and forth, the extent of amendments were all limited. Also because the scope of what they were planning to do was very limited, which was just to strengthen the national government, which was set up under the Articles of Confederation. Does that clarify? Yes, I can hear you.
So I feel US has always had a very rigid constitution. So do you really think that's one major factor which helped US in becoming one of the developed country and even one the most powerful country in the entire world? So do you really think that rigid constitution was or is helpful for US?
Yanni, do you want to try taking that question?
Actually, I want to leave the floor open for students to answer
Okay.
that. If anyone online or offline wants to answer that, because we want to facilitate more of a discussion between the students than answer the question ourselves. So I would love if somebody online could answer the question.
Hello, am I audible?
Yes.
If I'm not wrong, I suppose what she meant to ask was about the flexible nature of the Constitution. Am I right? Yes. So, if the debates between the stability of, if the debates between the stability or a flexibility of a Constitution, I think to imagine an ideal Constitution, I think it really has. It's dependent on a lot of other factors, the nature of a country, the historical progression of the constitution in the country, and the system of government. So I think that's what I feel about it. So yeah.
Yeah, I think it's because of the federal nature of the constitution in US that they are way more developed and it's easier for them to take things ahead and not because of the written nature of the nation. That's my opinion. Ma'am, if I'm audible, like you spoke how the difference between the Indian constitution and the United States of America's constitution, that is with respect to the procedure established by the law and due process. So how do you think the procedure established by law has made a significant difference in the Indian constitution? And why do you think it was adopted? And when Justice Frankfurt himself suggested procedure established by law?
Meenakshi, you're on mute.
Do any of the other students want to try answering that? How do you possibly think procedure established by law versus due process was somehow a better option to adopt?
Can we also request the law school to keep their video on so we can see who's speaking?
Louder.
Hello, ma'am. Ma'am, I'm on the rear side of the camera, so that is why you are not able to see.
Okay.
How the difference in both parties are there?
I lost you there. I can't hear you. I'm sorry.
The both choices that procedure law and due process of law, how it had made a significant impact on both countries. What
I wasn't able to follow your question. I think you're not audible.
Hello, ma'am.
I can hear you now. Tell me.
Yes, ma'am, you got the question right.
Mhm.
Question was like how the difference between procedure established by law and due process of law has made a significant impact on both the countries war over
Do any of the students want to try answering? Do you think it's made an impact? If it's made an impact, and how do you think it has impacted the two countries?
We can't hear the person who's speaking.
I'd like to make a response to an earlier question.
We can't hear you.
Can you hear me now?
Yeah, better.
Yeah, I'd like to give a response to an earlier question by my friend. So she asked whether the US Constitution is rigid, but I think the Constitution is a working Constitution, so it gets updated every single day, every single week, or every single month, because the US Federal Court and the Supreme Court keeps on providing landmark judgments. For example, Roe v. Wade. So when this keeps on happening, there's always space for progressive society, and it's not. That is the key.
I think we lost you in between. Hello?
Hello?
Yeah, we lost you in between. You were saying the Supreme Court comes out with judgments, and then after that, I think we lost you. Yeah.
Yes.
Better. Yeah, slightly better.
Yeah, so what I want to say was that the Constitution is given landmark judgment. So even though the Constitution is very small and it's a very early Constitution, you see there are so many things going on every single day in the federal court and Supreme Court. So that is the reason US asked for precedent.
Are there any other responses? Anyone else who want to say something to the point raised? Also on due process and procedure established by law? Sorry, there's a lot of disturbance, but we can't hear anything.
Can you hear me?
Yes, I can hear you now.
So I think though Article 21 says explicitly about procedure established by law, India follows due process of law and which has been decided in many cases. So, but I'm not sure why we still have, why we have changed it. We deliberately changed from due process of law to procedure established by law, but then we are following due process of law, but I'm not sure about that. But I think why procedure established law by law is better is because to curb judicial overreach. So even in this time of COVID, we have seen judicial activism being excessive, so where it interferes in other executive and legislative matters. So, but if you feel that independent and a strong judiciary is important for a country to develop, I think due process of law is better than procedure established.
Actually, I ask you to hold on to that thought, because the next activity we'll have is about independence of judiciary. So definitely hold on to that thought. Any other students who have anything to say?
Yes, ma'am. I have a question to ask.
Yes, I would suggest you ask your if the students are able to help you out first. Otherwise, I'm willing to step in.
Sure. So we had a discussion about a comparison of the number of amendments either of the Constitution has had, right? It's always been a point of awe for me, because in India we have about 104 as opposed to the US, also given the fact that it's been around for a longer time. And you had also mentioned about the fact that the amendment process being extremely rigorous. So could you probably enumerate on that? Could you probably let me know as to why the amount of stringency is being followed as it is in the US?
Do any of the students want to take a stab at this? Why do you possibly think the amendment process is more rigorous in the US? Okay, then I'll just maybe quickly just give my thoughts on it. It's once again going back to the concept of the federal structure that's adopted in the US versus the federal structure we have in India. Any amendment in the US would require ratification by the states. And here, the essential concept is to give states more say in the governance of the country. So in India, as we see where it's just the parliament which takes a call on amendments that are made, you wouldn't require state ratification subsequently to that.
I wanted to add to that as well.
Sure.
I think the founders made the process difficult because they also wanted to lock in political deeds that made the ratification of the constitution itself possible. And they realized that for a government to function well, certain ground rules in a sense have to continue as is, and they need to be stable. And yeah, if there's any student who wants to add to that, otherwise I think maybe Meenakshi, we could move on to the discussion question, and then we could see if the students want to answer that as well.
Sure, absolutely. So we have one discussion question for you. Kalyani, do you want to put that up on the screen? Just yeah. Basically, now that we've gone through the two constitution making processes, do you think the American and Indian constitution making processes were democratic? I'm just gonna, maybe students can take about 5 minutes to think about it and then come up with your responses.
Ma'am, actually, I feel definitely the answer is yes, according to me. Because, am I audible?
Yes, we can hear you.
So in my opinion, it's definitely a yes. Because both the American and Indian constitution, both the processes, during the process, much importance was given to the people. Like everything was for the people. So I think it's definitely democratic in my opinion.
Okay. Anybody else have any other takes on this? Or do you want to add on to her point? Please feel free to.
Yeah, sure. Just like to add a point to what we have said. Like,
sure.
It's not just democratic, but the Indian Constitution Assembly was even more transparent because the Constituent Assembly debates are still available. You can just refer to them and how the debate went on and all that. And that's how democratic the Indian Constitution making process was.
Anything else? Anybody else?
I'd just like to add a point to that. Like, the Indian democratic system was extremely transparent. The committee in itself was divided into various aspects with 270 plus members from different castes that we have. The SC/ST specifically had 45 members, if I'd like to add on to that. So each and every group was given extreme importance, whereas I just have a question for you here. When the constitution was in the making, we had 13 colonies then, and game had 13 member committees. It was a 13-member committee. So do you think is that democratic enough to form a constitution? Like you said, I understand that there was a center and state. So comparatively, I think the Indian constitution was transparent, far more transparent than the US constitution.
Just a clarification that I just want to make there. The 13-member committee drafted the Articles of Confederation. In the Philadelphia Convention, they had representatives from 12 colonies. Rhode Island didn't send, and there were about 55 delegates in total from these 12 colonies. So just to clarify that. So I understand that your point on representation. Does anybody else want to add to the point on representation, or you want to highlight other features of the two processes?
feel free to put in your comments even in the chat box. We can raise that if you're not comfortable speaking.
Yes, if I may.
Of course, go ahead.
So I believe that in true sense, both of the constitutions were not really democratic because we had representation from different parts, but that's not really what the people wanted. And even though the constitution was transparent and it's still available, there's nothing that we can do about it. Like even if we look at the constitution assembly debates as well, a lot of amendments were posed by different members. But once, with due respect, once Dr. Ambedkar, if he had posed his opinion saying so and so amendments that I do not think stand a chance, they wouldn't even get argued upon later on. So in my opinion, I don't think in true sense they were democratic. What we tried to do was a representative democracy, which is much different from what it is in Switzerland, which is understandable given the population, but it's still not completely democratic.
If I may, I would like to take a different stance. I think the Indian constitution making process was completely democratic because the representatives were freedom fighters and the national leaders who had a huge mass fan following. And like my friend had mentioned, they all represented a particular caste system or a diverse group. So I think in the Indian Constituent Assembly debates, it's very visible that everyone had different opinions and all of those were put forth. And the fact that every clause, every article was highly debated and decided upon, except virtually all articles were debated, except the universal adult franchise. I think that itself speaks about how democratic the Indian constitution making process was. And regarding the transparency, I would say that comparatively, the Indian constitution making was more transparent as it was the debates were open to the public for to look at also. However, I would also like to point out that both Hamilton and Madison took to the public through the Federalists the procedure of how the constitution was made. So I think the American constitution making was also fairly democratic. It was fairly transparent. But I would say the Indian constitution making was a lot more transparent than the American one.
So I would like to answer Sona's question. I think, first of all, constitution making process is never ending. You can't just say that particular period, during that period, the drafting committee was drafting, and you can't just say that was the constitution making process, and it's still going on. Although at that time, as you mentioned, it was a representative democracy, but even now the constitution making process is going on, and now you can see all the people are participating in it. Like we have so many amendments coming in. I think all those add on to the democracy of the country. You can't just tell that, like although at that time it was a representative democracy, but now I think the constitution making process is still going on. You need to call it completely democratic.
I completely get your point, but how do you think it's not representative democracy?
Yeah, I would like to add on this point. Like I would like to back Sonu on this. Like still it's a representative democracy. Still it is. And to me it would be for on and on also. Because a population like this can never be a full democracy. It has to be a representative democracy for it to be working. So what Sonu wanted to state was like Constituent Assembly was democratic, but if we have to say it was completely democratic, then that is a question mark because it was only a representative democracy. So that is what she wanted to make out.
But you know, another point, like if you take a country like India, it's very difficult to make it like every person participate in the process of democracy. Like obviously, population, as you said, is one major point, and you can't come. Like yeah, I agree with you. You can't make India a completely democratic country because of such a huge population. No, I'm just telling that you can't. Even now, I'm just not agreeing to one point that it was a representative democracy at that time because people that time
awareness about the constitution making process. There were so many challenges at that time. So yeah.
Is there somebody from who's logged in from online that wants to answer any of the questions? Maybe we could give a minute or two to someone.
Hello. So also about representation, there were, I suppose, 15 women alone. That's like less than 4%. And that I definitely do think it could have been way more democratic, going by the very essence of a constitution. So yeah.
I'd like to just make a point that we all know so much about the Indian Constitution and we don't know a lot about the US Constitution. So we would like you to elucidate that for us and give us a little more insight on how it was democratic for you. And so we are having our discussion here, but we want to, compare and analyze both the constitutions. So we'd like a view on that.
Right. Well, if there's no further thoughts, then I'll quickly answer that question and maybe close this discussion for now. We can have these thoughts. You can use these thoughts for the subsequent discussions as well. So quickly answering your question on comparing the two constitutions. Yes, one point that was brought up in these discussions is representation itself. Yes, one thing that we need to keep in mind is, yes, the 55 delegates who were a part of the Philadelphia Convention, mostly almost all white men who were lawyers, aristocrats, slave owners. This was the representation that we saw in the Philadelphia Convention. As opposed to India, yes, some people mentioned there was some caste diversity, but there was a lack of women representation that was there. In fact, Jaipal Singh Munda, one of the tribal leaders, had also commented that there's a lack of scheduled tribe representation in the Constituent Assembly. Especially, there was absolutely, I think there was no scheduled tribe woman member in the Constituent Assembly. So that's one aspect on representation. Second, on the processes that were adopted in the two constitution conventions. First, in the Constitution Convention, yes, there were discussions, there were deliberations among the 55 members. However, what in India, we saw a lot more deliberation. There was, like I mentioned, the committees. So there was the committee stages where they would have recommendations, you would debate on recommendations, you would pass amendments. There was a lot of back and forth. But like another student mentioned, there was a certain level of influence by the Congress party because there was a sort of party whip in place, for the lack of a better word, first when it came to certain provisions. The third thing that I would like to highlight is ratification. In the US case, the Constitution was, after it came into being, was ratified by each and every state. That process we didn't have in India. So was that a lack of democratic process is something that we also need to think about. Finally, just adding to the representation point, in India, the Constituent Assembly was indirectly elected. There were provincial assemblies in place. These provincial assemblies then elected representatives to the Constituent Assembly. That were to that extent, maybe the people weren't directly involved in sending the delegates to the Philadelphia Convention. So these are the 4 broad points that I can think of. Kalyani, is there anything you want to add to this?
Not really, other than maybe just the deliberations in the assembly itself. Because there was a process that was followed in the way that amendments were moved, in the way that assembly members voted on certain provisions, which is also in a sense showing the kind of democratic procedure that was followed within the assembly. So it's not just about the way the assembly was elected, but also the way the procedures took place in the assembly itself.
Right. If there's no comments, should we move ahead to the next meeting set?
I think that should be good.
All right. So I'm just going to share screen. Sorry. Is my visible?
Yeah. Would you like me to start?
Yeah.
Great. Could you slideshow it from?
Yeah.
Yeah. Perfect. Thank you, Meenakshi. So I am going to take you through reading set 2 really quickly so we can move on to the activity that we have for you at this part of the session. So I'm going to discuss 2 resources which will help us understand the doctrine of separation of powers and how it was deliberated in the US as well as India. And as we know, we get the idea of separation of power in the US from the Federalist Paper. And as Meenakshi explained, the Federalist Papers are a collection of 85 articles and essays written by Hamilton, Madison, and John Jay. And they wrote it under a collective pseudonym. And they did it to promote the ratification of the United States. And as we all know, the Indian side of it, which is the Constituent Assembly debates. So I'm not going to elaborate on that. I'll just move on to the readings itself. So the first one that we're going to...
Kalyani, I'm just going to stop you. Is the slide changing?
No, it's not. It's on the first slide.
I'm just trying to fix that. Sorry.
You could use the controls on the left side bottom.
Yeah, I'm trying that. Got it.
Perfect. Next slide.
Yeah, sorry.
Great, perfect. So on the 4th November 1948 speech that Ambedkar gives, he basically differentiates between America's presidential system of government and the parliamentary system that the draft constitution proposes. So he states that under the American system, the president is the chief head of the executive, and administration is, of course, vested in him. While the parliamentary system, the president is merely a ceremonial or almost a symbolic head. The American president is not bound by the advice of his secretaries, while the Indian president can't do anything in the contrary to his minister's advice. The American executive and legislature are separate, he states, and he states that the president and the secretaries, as in the US, cannot be members of the Congress, while in India, ministers are members of the parliament and only members of the parliaments can become ministers. So both are, of course, democratic executives in India as well as America. However, the American executive, he argues, is more stable, and while the Indian one is more responsible, and he has his reasoning for it in the speech that he gives. The draft constitution, he states, is a federal constitution, and he differentiates this from the dual polity in America by stating that they have dual citizenship, which we do not have. And in America, each state has a certain right of its own, which is not exactly same in India. He then moves on to talk about how, in a later speech, about how the judiciary must be both independent of the executive and also competent in itself. So he states that it is dangerous to leave appointments of members of the judiciary by the president without any limitation, that is, give executive the complete power to appoint judges to the Supreme Court. He also says that making appointments subject to the concurrence of the legislature entirely is not suitable either. And he says that this would lead to an influence of political pressure or political consideration and could be extremely cumbersome. He also highlights that appointments by the president in concurrence could be another problematic way of appointing judges to the Supreme Court, because it would give the CJI a veto power, and we don't want this either. So he sort of says that the way the draft constitution is framed is a midway. We're not giving any of the three organs extreme power in the appointment of the judiciary, which will help the judiciary have independence. On the 27th May debate, Anantasaina Mayangar also highlights that the Constitution provides for an independent judiciary, and that he also says that all three organs need to be equally important and independent, and every constitution needs to provide for this. If there's no independent judiciary, he argues, you can't guarantee individual liberty to the people. He says that the salaries of judges need to be fixed should not be fixed with an approval of president, because that in itself destroys independence of the judiciary. And we need to ensure that the rights of the judiciary are in no way reduced. Ambedkar responds to arguments in this debate to say that independence of judiciary from the executive needs to be clear, and this needs to be done by way of law. However, he says that you can't create an imperium in imperio, which is almost a supreme power of sorts. So you cannot give judiciary supreme power, but they should also be able to act without fear or favor of the executive. He says that salaries of officers need to be decided with the approval of president, only to ensure that there's uniformity and to reduce burden on the treasury. And he also says that maybe by way of amendments later on, there needs to be a provision like in the Government of India 1935 Act, where the Governor General could intervene if there's a conflict between the executive and the judiciary in the budget of the judiciary itself. In the last speech that Ambedkar gives, that we have provided as readings for all of you, he says that there of course needs to be a separation between executive and judiciary, and highlights that a person holding one office must not hold any other office simultaneously. So a person should limit themselves to a particular department and not be a part of multiple departments at the same time. He also felt at this point that the judiciary deals with adjudication of rights, and so will not be concerned with the executive. And similarly, he thought that the executive would not ideally interfere with the running of the judiciary. So that's the summary of the CAD debates that we provided to you. I will now quickly try to sum up the Federalist 51 paper so that we can move on to the activity. Thank you, Meenakshi. So Federalist 51 was written by James Madison, who is hailed as the father of the Constitution of America. And the paper addresses means by which appropriate checks and balances can be created in the government, and also advocates the separation of powers within the national government itself. And the first thing that Madison starts with is stating that you need a separate and distinct exercise of each of the powers of the government. And he says that this, which is separation of powers, is essential to preserve liberty. He borrows this from Montesquieu, although it's not in the reading, because Montesquieu states that in order to preserve liberty, it's essential that no person or group of persons exercise all three powers. And Madison also states that the appointments for the executive, legislature, and judiciary should be drawn from the same fountain of authority, he says, the people. So essentially, he's saying that elections should be the way that you appoint members of these three departments. However, he says that judiciary might not follow this principle. And that's because for members of the judiciary, you need people who have specific qualifications. So it is essential that they are not, it might be necessary that they're not elected per se. And to counter this, he also says that the permanent tenure will in itself destroy any dependence on the authority that confers the tenure on them. So if the long tenure will ensure that they're dependent on their own, even though they weren't elected by the people. He then moves on to give multiple ways that separation of power can be ensured. He states that each department should obviously have a will of its own, and it should be constituted in a way that members of each will have little agency in appointment of other members. Second, they would have as little dependence as possible in deciding the salaries for other branches. And also says that one way to ensure separation of power is to give each of the three departments necessary constitutional means and also personal motives. And when he talks about personal motives, he says that we are all at the end of the day humans, and we need to pit ambition of people from one department against the ambition of other to ensure that there isn't any overlapping or overstepping. I just want to highlight 2 more points before we move on to the activity. So he says that it's important to divide and arrange several offices to ensure that there's a check on each other. And he wants that the legislative branch could be the strongest branch. And the only way to ensure that this doesn't happen is to divide the branch in itself. That's one way. And the second way is to strengthen the executive. So with that, I will come to an end of my summary, but I will first maybe highlight the student discussion and then open up to any questions that you guys have, and maybe give you around 15 minutes to discuss, because I want to divide the class into 2 groups, and we can get on with the activity then. So I'm just going to read out the hypothesis. There is a proposal to introduce a commission to appoint judges to the Supreme Court. The commission will comprise of 4 people. One is the Chief Justice of India, the senior judge of the Supreme Court, the Prime Minister of India, and the Law Minister. 3 out of these 4 people must give their assent for every single appointment of a judge of the Supreme Court. So now we want to see how James Madison and B.R. Ambedkar will respond to such a proposal. I would suggest that the group that is offline could represent James Madison, and the ones that are online could represent B.R. Ambedkar. I will give you guys 15 minutes, but maybe if you have any clarifications that you need from us before you get into this activity, you can ask us right now. Okay, maybe the online group can discuss on the Zoom call itself, and the offline group can mute themselves and discuss. We can reconvene with the views that you have at around 10:45. You could either decide to pick 1 or 2 people who can speak for the group, or however you want to do it, that should be fine. We will give 2 minutes each for each side to put their views, and then another 2 minutes each to counter or discuss or whatever we want at the end. So I will let the groups discuss now, and we will reconvene at 10:45. Thanks.
Thank you, Kalyani.
Okay, great. I think everyone's out of the breakout room. Maybe we could start with the class that's offline. Maybe we could give you the chance to start putting out what you think Madison would have thought of the commission. You will have to unmute yourself in case you are already speaking, because we can't hear you yet.
Ma'am, before we could just start with the hypothesis discussion, can I just have the question one last time? Like just the...
Sure.
Yeah, thank you.
Is it visible on the screen?
Yeah.
Yeah, it's visible.
Would the students who are at the law school offline in the offline class want to start?
Am I audible?
Yes, audible now. Thank you.
Yeah. What we think as a group, what would Madison think about this commission for appointment of judges is that, so basically separation of powers concentrate on checks and balances, where each and every branch must be separate, and there must not be concentration of powers in one or few hands, which might lead to tyrannical or autocratic form of government. So then that should be protected. As Montesquieu said, independence of judiciary also plays an important role in that. And coming to this commission, I think Madison would reject it to an extent unless the deciding authority or the primacy is given to the Chief Justice of India, being the deciding authority and has the binding opinion. He can consult the other members and until a concurrence is met with. But the CJI must be given absolute deciding authority after consulting other members. here there are 2 executive members and 2 judicial members, and we think that the executive members can have influence on the judicial members, and the decision can be decision can be influenced. So we think CRI must be given principle only when Madison because even Madison wanted an active and independent judiciary. So yeah.
Yeah, adding to that, I'd like to quote the words of Madison. He said that the accumulation of all powers, namely the legislative, executive, and judiciary in the same hands or few hands, is just a perfect example of what tyranny is. He said that there's no more democracy. So what I feel is that even if a power of veto or supremacy is given to the Chief Justice of India, he would have not accepted it because he said that it is very important to keep each other in their proper place. Whereas now in this given condition or circumstance, we have 2 people important we have to concentrate upon. That is the Prime Minister and the Law Minister. Prime Minister and Law Minister are executives who have enough legislative control, and if they are also given an influence, an opportunity or a role to influence upon the judiciary, then that is obviously very a rule of tyranny, and there is not democracy at all. And if there has to be voting that has to be done, then we need a majority of 3 people to vote. So obviously 2 people would always be on one side which they favor for. So it is very easy to influence that one person. That one person can be anybody, even the Chief Justice himself. So on the either ways, however it might be, this committee would be abruptly rejected by James Max. That's what I feel.
Thank you for your view. Maybe we will give the floor to the students online, and then we could quickly have a minute of discussion and then move on to the next part of the agenda.
So yeah, I would like to take a stand. Basically, according to me, if Ambedkar would be in this situation and if he is asked to answer, then mainly he would have discussed about independence of judiciary, right? And in the Constituent Assembly also, when there was a discussion which took place, the main motto was to keep perception. It was regarding the keen perception of the end which had to be achieved, and that was nothing but independence of judiciary and to safeguard the dignity of the judges. Basically, in this hypothesis, there are 2 members from the executive and 2 from the judiciary. So if the main decision is left to the judiciary, and only if the executive is given given the right to express the opinions and to give suggestions and to help in the discussion, then it would be a much better thing, because in Ambedkar's view, this was mainly to counter the balance to political factor, like which may influence the selection by the executives. And Ambedkar usually felt that if the executive is given more power, then it would be a biased decision, as it may lead to abuse of power. So if mainly it is left to the judiciary, and if the final decision is left to the judiciary, then I feel Ambedkar would say yes for the commission of such group.
I'd like to add on to Chetan.
Yeah.
So as I believe, Dr. Ambedkar suggested a compromise scheme for appointments of judges, where he said both the judiciary and executive could have a say, but that has been misused because of political appointment of judges, and therefore shifting the balance of power to itself. And which is why I think the collegium system was adopted. So this model, therefore, the model that we have right now is something that Dr. Ambedkar did not suggest. So, looking at the 4 people we've given here, I think it is Ambedkar wouldn't have wanted it, because even though in the beginning he suggested that the executive have a say, it did not work out well, and therefore I also believe in voting what Chetan had to say. Yeah.
Thank you. Do each of the two groups have questions for each other?
I have something to say. So I think the answers given by both the groups are pretty similar, because none of us oppose the inclusion of people from other organs of the government in the panel. All that they wanted primacy given to the judiciary, and we wanted views from the executive, whereas the decision-making power vests with the judiciary. So I guess both the teams agree on almost the same thing. So there's not much to counter in this case.
Great. So that's actually, maybe I could just summarize, because that's exactly what we realized as well when we were making the activity. Although Ambedkar and Madison do actually arrive at a similar conclusion, the manners which they do it is slightly different, but they do agree that the independence of judiciary is of utmost importance. And maybe a couple of different methods through which they arrive at the conclusion that we wanted to highlight was that Ambedkar is one of the two who talks about political pressure and other such considerations, while Madison doesn't. And it's also, we also think that Madison thinks that tenure destroys the sense of independence, which Ambedkar doesn't highlight. However, this is also only because of the two different systems that are followed in the two countries. But yeah, Rachel, you're completely correct to think that Ambedkar and Madison would arrive at the same conclusion, because that's what we think would have happened too. Meenakshi?
Yeah. I have no further thoughts on this. If there are no further questions, then maybe we'll move the next part of the agenda. We have with us Professor Dr. Pritam Baruah to talk to us about how the founding movements chose to articulate common projects through distinct values in the two countries, and how that has unraveled in different ways for both. Professor is the Dean and at the School of Law, BML Munjal University. He's a seasoned academician and researcher with experience of more than 15 years. He's done work which is focused on how constitutional courts employ moral values in decision-making and the theory and practice of democracy. His doctoral work integrated insights from jurisprudence, cognitive science, and philosophy of mind in thinking about constitutional adjudication. Previously, Dr. Baruah taught at the National University of Juridical Sciences, Calcutta, and Jindal Global Law School. He was a teaching fellow at University College London and has held visiting professorships at the University of Ottawa, China, University of Politics and Law, Beijing, NLSIU Bangalore, and Humboldt University, Berlin. He has contributed to 2 commissions constituted by the Supreme Court of India and has also practiced law at the Supreme Court of India. His work has been published in many reputed national and international journals. Thank you, Professor Baruah, for joining us here today. The floor is yours.
Thank you very much. Thank you for having me, and thank you to CLPR and the US Consulate for doing these series of workshops, which I think are very important. And to tell the students who are here, I was there towards the end of your activity, and it was great to hear, how you thought, if you stepped into the shoes of, founders, so to say, of constitutional, founding moments, how would you have thought about it? And I think that's a very significant thing to do, especially today, because in India it continues, in the US also it's happening, that people are contesting some of the most agreed upon fundamentals of the founding moments. And what that requires, perhaps, is for people at this moment of time, especially constitutional lawyers, to be thinking about how the founders would have thought. Now, there are different ways of doing it. And I thought that, I will try and speak on something what I will call the continuity of founding, moments, to see how founding moments are employed today, especially in contexts where societies, seem to be deeply divided on the very common projects that founding moments, imagine for us. So I have a short presentation, with the online mode. I think it's good to see faces, but it's maybe something up on the screen would, be helpful. So I'm going to share my screen. But I would also encourage the students, because I have around 20 minutes, 25 minutes this session, and there isn't you have had a long session, and good you don't have another Q&A at the end. So I would encourage you that if at any point of time you have a question, raise your hand, or whatever technology you can use, stop me and please ask me a question. Right? So let me just quickly share my screen. So I hope it is visible to you. I'm going to put it on full screen mode.
Yes, Professor.
Yes, it is. So sorry, okay. So, these Greek, inspired architecture there, mostly because we think of these hallowed, architectures within which founding moments are deliberated, constituent assemblies, etc. But I think the idea of the continuity of founding moments is important, because sometimes we take founding moments to be articles of faith, and we think that these are uncontested things. And there is something to be said about that why do we think that way? Is it important to have uncontested agreement in common political projects? Or is it possible, and I think that question is very important today, that we still have common bonds that founding moments set for us, recognizing very well that we may not clearly agree on the values that were posited, at least in our case, half a century, in the American case, more than a century ago, right? So I think these questions are important for us to be thinking about, and that will be the focus, of my presentation. So, so you can see a table here. It's a quick table I have made of comparing some key features of founding moments in the United States and that in India. And I've put the biggest question first, if you see on that list. In America, in the founding moments and in the deliberations, you have some extracts from, the original papers and some extract from our, Constituent Assembly debates. But it is generally agreed that one of the major ideas of American constitutionalism is the orthodox idea of constitutionalism, which is to have limited government. Whereas in recently, the literature on constitutional theory and constitutional law in India has been speaking about this idea of transformative constitutionalism. And scholars are now thinking that perhaps often these two ideas are in contest with each other, and they cannot be performing similar functions. And we might want to think why. I think it's a good time to reflect on these ideas of what is limited government? Is limited government the only form of constitutionalism? Or is transformative constitutionalism something new? Is it something which comes only from the post-colonial context? So just as a way of introduction, we might think of limited government as something which has common roots in all forms of constitutionalism, whether we think of the roots in the French Revolution, in the American Revolution, or post-colonial constitutions like India. The idea that government's coercive power or the state's coercive power will be limited is an essential part of constitutionalism. It is often spoken of as a narrow view of constitutionalism. And rather, transformative constitutionalism is the idea that constitutions set out certain projects and in their founding moments. And those founding moments aim to transform our societies, its social structures, its hierarchies, into a new and mostly, articulated in liberal values of equality, liberty, dignity, justice, to transform societies which value that. And we see, therefore, that there are two different kinds of functions. One is a restraining function, and the other is a positive function. So in transformative constitutionalism, recent literature has pointed out that it is not a phenomena which countries like India or South Africa, where this idea of transformative constitutionalism started with Karl Clare, a South African academic, and found voice in the South African Constitutional Code. But recently, academics have pointed out that this has not happened only in India and South Africa. It has happened in other places. It has happened most prominently in Germany. It has happened in the European Union, in the United Kingdom, and even in the United States, where courts have put positive obligations, in different ways on organs of the state to transform their societies, to change social structures towards the goals that a constitution sets. So this is, I think, perhaps, and others would correct me if I'm wrong, the state of the art on the debate on transformative constitutionalism. But if you look at the next point there on the American side, I said that these ideas of private interests, which find their way into the Federalist Papers as the idea of factionalism, as a problem of factionalism, which bared heavy on the minds of the constitution makers in the United States, had a lot to do on why limited government was of centrality for the Americans, and perhaps did not gain as much focus in recent scholarship in India. And I think at the time of the Constituent Assembly debates, though, there was equal focus on both. But we still think that, we are a bit different in terms of the very grounds from which our constitutions emerged. So the idea of private interest was, in brief, and, I put this very crudely, is this, that in the United States, the constitutionalists who went on to make the draft the US Constitution overthrew a colonial power, but it was a let's say a monarch situated across the seas, and with whom and the society there, or the monarch society in the United Kingdom, there were not too many differences. There were similar societies, but there were different kinds of private interests, commercial interests, political interests, which were present in the United States at that time. And those interests clearly got together to overthrow the ways of functioning of the monarch of the United Kingdom and the Crown's government in the United States. And that is why when the monarch went away and that regime was absent, there was suddenly a space. And what was the space? We think of it as a democratic space, but it was occupied by many different groups with private interests, which was not necessarily looked upon as something bad, but rather as something which would, let's say, propel or fuel, commercial and other kinds of development in US society. And therefore, factionalism was not looked upon as necessarily a bad thing, but it was something that had to be dealt with if you were to arrive at a common good, which the Constitution was going to, design for your society. And therefore, the focus of the United States founding movement was not about removing the causes of factionalism, because that would mean removing the private interest, the very interest which the Constitution makers in their different factions held very dear to their hearts. But the idea was to remove their effects, right? And if you compare that to the right-hand side on what happens in India, when the colonial government left, and they left slowly, but they did leave, once the Constituent Assembly was formed, there was a sudden major chunk of leaving, and that, brought in front of us a society full of social divisions, and I think the word is, missing here, which is, common consensus was absent on several things, because we had a deeply divided society which was impoverished, right? An impoverished, divided society, and not in terms of private interests alone, but in terms of social structures. Let's say there was caste, there was gender, there were regions. So the way the space was occupied by different kinds of groups were people with different kinds of ideas, and therefore different visions of what should be paramount in making our constitution. And therefore, instead of speaking of, as Madison said, not removing the causes, but the effects of the private interests on our government, in the Indian case, we actually thought about removing the causes of inequality and poverty. So that was something that fuels a transformative project. Now, the other important distinction, I think, was about the idea of property, which played a central role in the constitution making in the United States. So why did it play a central role? It played a central role because suddenly the old ways of dealing with property, which was through titles and rights which were given, which followed, flowed down from the British, from the Crown's government, you now had Madison and especially Jefferson who were speaking about let's say, allocation of property, which is a question of justice on the basis of what society thinks rather on the basis of what the state thinks. And therefore, this idea was about what we see, a liberal idea of property, and many argue in the US was a libertarian idea of property, where we think about the default position as people having property rights which are not disturbed unless you can prove historical injustice. And that is why the idea which was paramount during the US founding was the equality of opportunity, a specific kind of equality. Non-discrimination and the broadening of equality came much later, when they had to deal with questions of race through courts. But at the founding moment, it was equality of opportunity which was important. And the words used were that individuals should be able to exercise their faculties, which is talents, to acquire property, and there should not be any hindrance to that. So that's the kind of ethos that was driving. But if you looked at the Indian project, then from a property point of view, it was colonial continuity in terms of our common law on property. There was colonial continuity. The right to property was recognized as a fundamental right. But as India progressed on its constitutional journey, we saw that there was constitutional dilution of this right, which is in opposition to what had happened in the US, that where it was entrenched very strongly as a liberal idea of property where ownership was very important, right? So there was equality of opportunity on the one hand, and equality of status, non-discrimination, and also equality of opportunity, one of the many that found way into the Indian Constitution. The third is, not the third, but the other idea, which I think slowly starts bringing in more agreement between the two countries, is that of separation of powers. It was very strong in the United States, which embodies the values of independence, that there has to be independent organs of the government, independent regulatory bodies, which can think about, which you see in the next point in democracy, which can think about issues of governance in a disinterested way. So the idea of separation of powers has something to do with this idea of disinterestedness, which comes from independence, and also to a great extent from immunity from other organs of the state and others that exercise state power. Whereas in India, we see that there is a watered down version of separation of powers. It is there. We still debate about it, what kind of separation of powers, but because we adopted a Westminster model of parliamentary democracy, we see the executive and the legislature formally being part of the same house. But at the same time, we see now how the executive has suddenly become much more powerful, because you can't really distinguish between the executive and the legislature when you have really strong governments as we have today and as we have had earlier at the times, let's say, of Prime Minister Indira Gandhi, even Rajiv Gandhi. So we have had strong, executives. And right in the beginning, even, Jawaharlal Nehru's government, there were tussles with the court, and we saw that classic case of property ultimately, coming through with the, basic structure doctrine. All this was because we didn't look at separation of powers in as watertight way as, the Americans did. But there are some common themes which flow down slowly. You see, the idea of a republic, that people's representatives will be making decisions about government, is common in both houses and in both countries. And the idea that there will be counter-majoritarian rights, which will be, I don't like the word enshrined, but which are posited in the Constitution, is something which is common, right? So we see that, so we do see that there's a difference of context, but we slowly arrive at certain very important, I think, legal and constitutional agreements about, the idea of democracy, a republic, and counter-majoritarian rights, which are common. And we see that apart from democracy here, the other two have a restraining role. They have a restraining role in the sense that it's the representatives of the people who represent the people will be making, decisions about government, but they are not free to do whatever they want because they represent the people of a country. The consent of the people is important. They cannot get into a house and choose to do whatever they want. And the idea of counter-majoritarian rights goes even further in restraining, which says that the idea of constitutionalism in a democracy is not that if you assume majority, which is important, that and that you can make whatever decisions you want, but rights are guarantees given to us at founding moments which cannot be watered down, right? So I think these are some differences and commonalities between the two founding moments. And I quickly want to move to some ideas because I think I just have around 2 minutes. I'm going to skip this slide because I think I've covered this. But we should today think about what is the function of a founding moment. Why are they so important? So one thing that founding moments do, and the philosopher John Rawls spoke about this and brought this, in the 1970s to the forefront of political theory, is that they provide first a kind of basic agreement or grammar of our social relations. That we may think of ourselves as a plural society, but founding moments articulate projects which hold us together. Even for us to be able to disagree with each other, we must have some common terms. And Rawls spoke of them in terms of public reason. The idea that that whenever you have disagreements, there are some reasons which are publicly posited in nature, in the sense that they are not your self-interested reasons, but reasons which we have all agreed will be the touchstone of decision making, which are guaranteed through texts like the constitutions that we are going to look at. And that public reason serves as a limitation on the kinds of reasons that we can use in order to get on with our life. So it has a restraining function. And in all of this, I think the transformational part is important. That can we think of the function of transformation within this restraining idea of public reason? And I think that it is inherent. It is a part of this, that people have to transform themselves. When you think constitutionally, you take your, or you want to argue on the basis of the constitution, sometimes constitutional disagreements are the deepest political and moral disagreements that our societies face. And if we are able to change our own views about our deepest moral and political commitments, that is transformation happening at an individual citizen's level. And so this idea of transformation is social transformation for sure, but the idea of constitutionalism also holds within it an idea of transformation, where individual transformation, or by reflecting upon your core intuitions, moral or political, your beliefs, is inevitable. And we must think of that in plural constitutional societies. The last slide I have is about whether we should look at founding moments and the values in our constitution as articles of faith. The elephant in the room is that we cannot. There are people in both the United States and in India who sometimes think that our understanding of whatever it is, whether it is equality, liberty, dignity, autonomy, fraternity, freedom, property, are just radically different. We have radical disagreement. We don't seem to be agreeing. So how can we take away something from what our founders did when we are faced with such radical disagreement? And I think it's a very important question, because our founders were faced with such radical disagreement, both in the United States and in India, right? And within that disagreement, they generated a political grammar, as opposed to the exercise of pure coercive power, right? To build together a society, provide a project which we can work upon together. And today we must think about it, that what is it that threatens a return to pure coercion, where you don't believe in what the state, let's say the organs of the state believe in, and then you face the brutal brunt of, coercive state power. It's happening all over the world, and we're talking about authoritarian democracies. How do we think about that through the lens of our, let's say, constitutional founders in the founding moments? And I think that there is a lot to be learned if we focus on not what was said during the founding moments, but on agreement on second order considerations, which is the idea that agreement of how did they want to proceed such disagreement. So founding moments hold processes of thinking about radical disagreement, which we must look at both at the time of the US Constitution's founding and the Indian Constitution's founding. And focusing on those processes perhaps is better than forcing through our own view of values, down other people's, throats, even if we think that it is right. Frankly, we don't have that luxury in today's world. So I think that, and I will end with this. I've overshot a minute, but let me finish this here with the last point, that founding fathers were forward-looking in terms of how they were going to address the disagreements that are there in society and try and attain objectives that we want for our society. Whereas a lot of constitutional interpretation today is backward-looking, and that is the received wisdom, that we look at the founding moment to find us a right answer. But I think we look at the founding moments to find out how do we arrive at a right answer. The right answer may not be there. And therefore, I think founding moments urge us to think about responsive constitutional interpretation, that we look at these founding moments to see that there is a way in which constitutionalists responded to the problems of their time by using analogies, by having forums where you debated together, where you agreed incrementally on certain values and then went on to more radically, let's say divisive issues. That kind of incrementalism, that kind of responsive constitutional interpretation is the need of the hour. And I'm thinking about courts here, that courts, especially in divided societies, must look at the founding moments, not to tell us, as several of our judges said, dignity, liberty, equality are the founding faith of the Constitution. I don't think that helps. What helps is that how did we arrive at dignity, liberty, and let's say autonomy as the founding, equality as the founding faith of the Constitution? How did the founders arrive at that? So processes, I think, therefore, are important and is the need for our times. I'll stop here and thank you for the opportunity. And I'm happy to answer any questions if there is any time. So over to you.
Thank you, Professor Baruah. Do the students have any questions?
I think there's one question in the chat box. Maybe I can just repeat it. It says, what is your opinion of the Constitution being a dead hand of the past?
So you're on mute.
Yeah.
The usual way of answering this is to say the popular thing: constitutions are living trees, they're living documents, and we work with them. But I think that's a very idealist way of looking at it. I think constitutions are what we make of them at any given point of time. So if we really think that our constitution is dead, it's dead, right? So, but let me tell you that, and here some people don't like it. I sometimes think being essentialist sometimes is okay, but ultimately, essentially, it's a document which lays out a project. It has broad terms which collects people and are paradigms of agreement, and they serve as fertile ground for interpretation. So by design, constitutions are supposed to be alive, but as words, they can be dead. But it is people who bring life into it, and because we have made them, and they have to be for animals and everything else. But therefore, my answer is no, they are not dead hands of the past. My answer is that they are the ground to bring new life to social problems that we have, and they hold important wisdom, because people went through we should not be very confident that our generation is it knows the best. I think the new generations do know better, but sometimes people go through periods of time of reflection which we ought to pay attention to. So simple answer is no, they are not dead hands of the past.
Are there any other questions? In that case, I think because we're just about in time. So thank you so much, Professor Baruah, for sharing your thoughts on how the constitutional founding moments have had an impact both on contemporary political and legal landscapes, and also letting us understand the values and processes behind adoption of those values in our Constitution. Students, just to let you know, we'll take a break for about 15 minutes now, and then we will carry on with the next session. If there are no other comments or questions, we'll take the break and reconvene in 15.
Thank you.
Thank you so much, Professor.
Thank you, Professor.
Thanks.
All right. Okay, then we will start with our second session for the day, which is on merit and affirmative action in education. Just to start off, I thought it would be useful rather to look at the legal or relevant legal provisions in US and India for affirmative action. First is the American Constitution, the 14th Amendment. Like I mentioned, the Constitution, when it was adopted, did not have any civil liberties or equality provisions. They were introduced later. And the equality provision particularly, which was in fact there in the Declaration of Independence, but was lacking in the Constitution, was introduced by the 14th Amendment in 1868. And it's similar to our Article 14. And I'm going to just read the relevant portion, which is that any state, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of law. You can see the similarity of terms used here, and then you will see that in Article 14 as well in our Constitution. Apart from this, there is Title 6 of the Civil Rights Act of 1964, which reads, which I'll read out, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or actively receiving or activities receiving federal financial assistance. So these are the broad provisions in the US that will be relevant to understanding affirmative action, the affirmative action framework in USA. Then moving on to India, we have a slightly broader conception of equality, and we will see some explicit provisions, which I will highlight. As I mentioned earlier, Article 14, similar to the 14th Amendment of the US Constitution, states that there will be equality before law and that there will be equal protection of the laws within the territory of India. And it also, and then you have Article 15, which is a strict anti-discrimination provision, which prohibits any form of discrimination on grounds of religion, race, caste, sex, or place of birth, similar to maybe the Title 6 of the Civil Rights Act. And here, it's important to note that we have two explicit provisions. One, 15.3, which allows the state to make special provisions for women and children, and 15.4, which also lets this, permits the state to make special provisions for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and the scheduled tribes. Then we move to Article 16, which is the, I think there's an issue, or I'll just take you through Article 16. Article 16 is the Equal Opportunity Clause, which ensures that there's equality of opportunity in matters of public employment. Once again, in this, there's something very, there is explicit affirmative action provisions in 16.4 and 16.5. So this is the basic constitutional architecture regarding affirmative action in India. Now, before we delve into these provisions itself, I thought it may be interesting to look at what merit means and what merit means for affirmative action. And a good starting point for this is going through the Michael Sandel piece. And this is an excerpt from his book, The Tyranny of Merit, What's Become of the Common Good. Now, in this excerpt that we had shared with you, Michael Sandel describes two forms of societies. One is aristocracy and the other is meritocracy. Now, he states that in aristocracy, the method of distributing income and wealth is based on your birth. So if you're born into a wealthy family, you inherit income and wealth. And if you're not born into a wealthy family, then you are poor. Or if you're born into a peasant family, you're poor. And the second form that he describes, which is meritocracy, he says is that is a society that distributes income and wealth not based on which family you're born into, but as a result of your efforts, your talent, and your skills, which basically prioritizes individual merit over anything else for distribution of income and wealth. So what Michael Sandel says is, put yourselves in a situation where you don't know which family you would be born into, a rich family or a poor family. Which form of distribution of opportunities and income and wealth would you prefer? He feels most people would say meritocracy, because it's unable to gauge which family you're born into. Meritocracy is something that thrives on individual talent and skills, and therefore would be something that would be suitable in that uncertainty. But he also highlights two major problems with meritocracy. The first, he says, is that in meritocracy, you're assuming that everyone is at an equal position, and then they're competing based on their skills and talents, which may not be the case, because often your skills, your talent, your potential are all influenced by a certain history or a certain privilege that your family may have that gives you exposure to be able to hone those skills and talents. And the second problem he highlights with meritocracy is that meritocracy doesn't necessarily address inequality. It doesn't help solve inequality. It is still distributing income and wealth in an unequal manner based on talent, but it's just a justification for inequality, but it doesn't address unequal distribution in and of itself. So this is the broad conceptual framework with which Michael Sandel is analyzing merit. And it will be interesting to see how then in the next reading that we had shared with you, Ajanta Subramanian is applying this concept of meritocracy in the Indian context of elite engineering institutions. And she starts her piece by talking about how once the constitution came into being, many upper caste individuals adopted two strategies to challenge affirmative action provision. First, they believed as citizens of the liberal democracy, they could use the constitution's baseline of equality and non-discrimination to challenge reservation. But they also argued that as upper caste, they were quintessentially meritocratic. It's interesting that she makes this observation, and we will see how she concludes on this in the latter half as well, towards the end of her piece. But then she moves to understand the constitutional framework itself and how the constitution discusses equality and redistribution. She starts with Ambedkar's quote that he makes in the Constituent Assembly in November 1949. She says, and I quote, "On January 26, 1950, we will have equality in politics and inequality in social and economic life. We must remove this contradiction at the earliest moment, or else those who suffer from inequality will blow up the structure of political democracy, which this assembly has so laboriously built up." Ambedkar also highlighted two forms of inequality. He states, "On the social plane, we have in India a society based on the principle of graded inequality, which means elevation for some and degradation for others. On the economic plane, however, we have a society in which there are some who have immense wealth as against many who live in abject poverty." So there was a general agreement in the assembly that there was graded inequality because of caste and class disparities, and this required some form of redressal. But the consensus was not there on how to arrive or what were the mechanisms to address this. So they had to weigh two very important concepts, balance them out. One is equality of opportunity, and second, the need for redistribution. Ambedkar also highlights this in the Constituent Assembly debates, and he says that to safeguard two things, namely the principle of equality of opportunity, and at the same time satisfy the demand of communities which have not had so far representation in the state, it is important to arrive at a mechanism that does this in a fair and just manner. What he suggested was to limit the amount of redistribution you provide and to qualify who are beneficiaries of this redistribution. In this way, what Ajanta Subramanian thinks is that Ambedkar, in a way, is reinforcing the concept of formal equality as the basis of the Indian constitutional provision. Because he, in a way, feels that affirmative action is somehow conflicting with concepts of equality, and therefore there was a need to balance it. This sort of understanding was prevalent in early judicial pronouncements in independent India as well, which, if you look at, starts with the state of Madras versus Champakam Durarajan in 1951, where there is this concept of formal equality is held more dear than questions of substantive equality. But this soon changes over a period of time when we look at Indira Sani in 1992 and then Ashok Kumar Thakur in 2008. She shows that there is an evolution of jurisprudence and that courts are now looking at the need to sort of balance questions of formal equality and substantive equality and have mechanisms to redress the historical wrong done to many communities. Finally, she concludes with one interesting aspect, so that now that courts are on the same page with many anti-caste movements, there is a slight difference that she notes here. First, she says that the judiciary still looked at the upper caste subject as the ideal citizen who's defined more by individual merit than by his or her caste identity. So what she feels is courts and the general popular perception is still that the concepts of merit, questioning merit, comes only with, and obviously caste identity comes only with the so-called reserved category and not the general category. She says that it was only the reserved who came to be marked by history and identity, while the non-reserved stood in simply for casteless ahistorical excellence, which ties in with the earlier point that she had made in her piece, which is that upper caste individuals for the longest time still do think that they are custodians of meritocracy, and any sort of infiltration of that through affirmative action is disservice to the concept of meritocracy itself. So those are the basic arguments that she raises in her piece. So what I would do now is for students to just take a moment to reflect on the two pieces, the provisions, and if you have any questions, please ask me. Else what we can do is move on to the discussion. Any questions?
Am I audible?
Yes, you're audible. Please, Sammy.
We don't have any questions. We can move forward.
Okay, to the discussion? Sure. All right. Then I'll ask you the first question for students to respond to. How do the US and Indian constitutions approach affirmative action?
You could maybe take some time to think about it and answer in a minute or two.
Maybe a starting point to think of is, does the US Constitution even permit affirmative action? What do you think? Start with just the text itself. When you read the 14th Amendment and Title VI, how do you think the US Constitution looks at affirmative action?
Can I comment on that?
Yes, please.
I think the US affirmative action would be something of a preferential treatment to women and per se like the Black community or like the minority group, whereas in India, it's more of the caste system, to put it more precisely, the untouchables.
Mm-hmm. Right. So you're talking about the beneficiaries of affirmative action, right?
Yes, yes, yes.
Okay, that's interesting. We have Prakriti has said something on the chat, so I'll just read that out. She says there has been a steady inclination towards composite affirmative action in the US, while any change towards a casteless society is met with political and politically motivated conflicts in the society. Anyone have any comments on that? Would like to share your thoughts in India?
Am I audible?
Yes.
So from my understanding on affirmative action, differentiation between the US and Indian constitutions, the US follows formal equality where they don't really believe in giving rights to the minority or to a deprived class. They, like I said, they believe in formal equality, but in India, there is equality of opportunity that is given a very great importance, even in the constituent assemblies, because the classes and the caste differentiation here was, I think, more in India, and hence the prejudice that the minority groups have faced here should be curbed, and hence we Indian Constitution gave great importance to affirmative action. A very good example would be the reservation system that we follow, which is still prevalent even today in all kinds of examination, and even when it comes to giving positions in the government or every single way, reservation plays a deep role. And recently, I don't know, affirmative action has also been banned by 9 states in the United Nations. So, United States, and I think there's a very different stance that affirmative action has taken place in both these countries. So, the approach that we are trying to look here is completely different as that of in US and in India. Where in India, we have been given deep recognition to affirmative action, but whereas in US, because they follow formal equality, there is not much prominence of affirmative action, though they do recognize minority rights, such as the differentiation and diversity. That's my take on it. Am I audible?
Yes, we can hear you.
Yeah, I just want to add to what Annie has stated. The Constitution as such, be it Indian or US, we use words like no. So that doesn't really promise an affirmative action. Instead of like, except for Articles 21A and the Directive Principles, nothing really gives a positive right to the citizens or to people in general. What we see is instead the protection of certain rights, for example, the liberty aspect of it, or equality also. It always starts with no citizen shall be discriminated. It never goes like you have the right to equality, right? So I think that ways our constitutions don't really give us affirmative rights, but they protect us from taking them away.
Any responses?
Yeah, am I audible?
Yes, I can.
Adding on to this, I would like to first state that the US Constitution, where it was formed, it even recognized racially black people and women. But the Indian Constitution as such was never like that, because if I have to put it out within circumstance, then US Constitution is the people or the society there feels as if like the world is free and everybody has a chance. So there is no need for a reservation or quota. Whereas in India, it is not like that. We are trying to give them a space. We are trying to give a circumstance where they can grow and evolve. So as Tanvi has pointed out, both of these nations have seen affirmative actions in a different perspective. And in fact, the judiciary of US has held that affirmative actions are unconstitutional. And only now it has been partially abrogated and partially it has been accepted into US. So yeah.
Any students who joined in online?
I'd seen a raised hand by Tita.
Tita's commented on the chat. She says, I think US provides equal protection. So, Tita, do you want to add to that, or would you like others to respond to it?
Am I audible?
Yes.
So I think the affirmative action policies of the US, it concentrates particularly on few areas like education, like license, grants, contracts, like that. But the affirmative actions of Indian Constitution, it focus on the basic livelihood of the citizen. Like be it the place they live, everything, their basic life, from the basic necessity of life, the affirmative action policies are implemented in the Indian Constitution. But whereas in US Constitution, it focuses on only particular areas, not on the basic day-to-day life. That's my point.
All right, thank you. I think just adding to Tita's point, I'll probably ask another question which someone could respond to. Is yes, while we say that the US Constitution, they don't look at affirmative action in a very beneficial manner, it does provide for equal protection of laws. Don't you think maybe, don't you think that this provision can be used for ensuring there is substantive equality? Similar to what we do in 14, where we have the reasonable classification test, which permits differential treatment for a certain, certain objective. Could something similar not be sort of read into the US Constitution?
So responding to that, yes, equal protection is guaranteed by, if I have to understand about that, every nation gives equal protection. Like every constitution ensures that. So if we could judicially interpret by way of judicial activism, we could ensure that. But the question of whether it is being explicitly mentioned in the constitution, then that means then we have to say that US does do that, but partially India has affirmative actions in its constitution.
All right. Thank you for that. Any responses to that?
I would like to say, even though India has like provisions that explicitly, let's say, like reservation quotas and terms like that we have in a constitution, but I think eventually, like Sonu said, it's about the political will. And there's been a lot of controversies throughout history and a lot of political resentments and all that, which is really time consuming for any such affirmative actions to take place. And I think when we look at all these proactive policies, it really comes to the political end of it. So yeah.
Yes, we can hear you.
I would also like to add, by saying that affirmative actions are basically based on the needs. US has particular needs, and India now has particular needs. So as far as India, it is we all focus on reservation because it is required. Because after so many decades, still we are being called developing nation, and we have not yet been developed. So our focus is basically to be developed first, and then improve on other things. And when we see US is already developed, and because of which the other things like grants, like those areas are being focused for all these affirmative actions. So I feel these affirmative actions are basically based on the needs. And as India is required for such areas which need improvisation and need development, their affirmative actions are being used, and that is why in India it is all very much explicitly mentioned in the constitution. Whereas in US, it has already been 2 centuries almost. So they're already focused on all these points of people getting developed and all those things. So I feel that is the main reason India is having more affirmative actions when compared to US.
I think these were brilliant points. Just before we move to the next question, I just wanted to say one thing. So it's also important to keep in mind, like David actually said about political will, it's about how these constitutions were drafted, and like how we mentioned representation in our earlier session, all of those have also made a difference in ensuring that there are certain provisions, in both constitutions. So just that was my concluding remark on this question. So we'll probably move to the next question. So the next question is, how do these constitutional and judicial frameworks view merit? By these, I mean the US and the Indian constitutional and judicial frameworks look at merit. This you could draw in from your readings, look at the text, your own views. Please feel free to answer or respond. Maybe a starting point is to think about, do you even think, what is the relationship between merit and affirmative action? Is it a contradictory relationship? Do they, do they supplement each other? What do you think?
I think they are supposed to supplement each other, although I don't think I can say they do.
Right. Do you want to elaborate?
If you're looking at an ideal, if you're going to look at an ideal way of, ensuring equality or even democracy in itself, the crux of it, I think it's important that we have affirmative action when we consider unequal opportunities that people face, and like I don't think any of the world countries have an egalitarian society right now. So I think it's really important that we ensure merit is based on equal opportunity. So it's really important to address whatever it is, race or even caste systems, all different forms of discrimination systems around the world.
Thank you, Devadarshini. Anyone else?
I just wanted to add one more thing to this.
Yes.
That when we look at merit from a perspective which does not have equity involved, then that becomes because then there's reservation and there's not completely based on merit. However, when we look at equality between equals, which is what I think our constitution definitely supports. So in that case, merit is accommodated along with equity.
I would also like to add on that the Indian Constitution has striken the proper balance between affirmative action and merit, because in the Indira Sawhney case, it was made clear that though employment opportunities can be reserved for the economically backward classes, it is important to note that the promotion would not extend, the reservations would not extend to the promotion part of it. So I think the Indian Constitution provides opportunity for everyone to take charge of their educational and employment opportunities. But the way they proceed, the way they climb the ladder is based on merit.
I would like to now focus on the judicial framework. When I think of judicial framework, I think judiciary is playing an important part in the in reservation thing, because reservation is something that can be capitalized as a political will of any party or any person. So when judiciary believes that it is only an exercise of political will but not the popular idea of the people, then it is where it is playing an important role. We have also seen cases where the judiciary has stepped in and stated that reservation should not exceed 50%. So that is the balance that judiciary is trying to get. Like it is viewing merit and equality in it's both eyes of judiciary in case of this.
Yeah, adding to that, she said, not just judicial proceedings, but there have been various commissions also set up to look at the merit aspect, where we're giving equality to both, opportunity to the prejudiced part and also equality to the meritorious. So various commissions, one such example would be the monthly commission, was set up to make sure that the merit situation or picture comes into the framework that we are forming today and developing as we grow.
Anything else? Anything else anyone wants to say?
Just this, like we spoke of earlier about representation. I think it's not only about equal opportunities, but also about representation that we have in any sort of, offices or government agency. There, we need to have people from diverse categories in, to have results that favor all kinds of people. Yeah.
Any other comments? All right, so some great points were raised there on how the Indian codes and Indian Constitution itself views the concept of merit. And on the American front, while there has been no explicit provision for permitting affirmative action, if there was the political will, like many of you raised, maybe it could be read into the 14th Amendment and Title VI. Apart from that, the way the courts have proceeded in the US, just wanted to highlight one point, which is known as the strict scrutiny test, which I will ask students to keep in mind for the activity that follows. So this strict scrutiny principle basically states that the state can have a program or a law which makes a classification or gives preferential treatment only when there is a compelling state interest. And when it comes to, basically what the strict scrutiny test says is that, yes, you can have preferential treatment. It will not be violative of 14th Amendment, if there's a compelling state interest. 2, if it's narrowly tailored to suit this particular compelling state interest. And 3, it does so in the least restrictive manner. So I would just ask you to keep these 3 in mind. And often in affirmative action cases in the US, what happens is that they look at diversity and not representation like Divya suggested, but diversity as a compelling state interest for which preferential treatment may be given. So I think with this background in mind, it would be interesting to move on to 2 contemporary cases in the India and US, which Kalyani will take us through, followed by an activity.
Thank you, Meenakshi. Will you?
Yeah, I'm just going to share the screen.
Thank you.
I hope it's visible.
Yeah, I can see it. Okay, so I will quickly take you through reading set 2 of session 2. The first one is titled "Can Affirmative Action Survive It?" And it's by Nicholas Lemon, who is a staff writer at the New Yorker, as well as a professor at Columbia's Graduate School of Journalism. So he takes us through the history of affirmative action in university admissions in the US, and they've had 6 cases so far, and a new case now pending in the Supreme Court. The first case, which is of Marco De Funes, was moot because by the time the bench got around to giving the judgment, De Funes had already graduated from college. The second case, Lemon talks about, and he states that the majority voted against an explicit numerical version, almost like a quota system. They said that wasn't allowed, but voted in favor of a lesser explicit version of affirmative action. So this was the Baki case. And basically what the Baki case said was that affirmative action is okay. However, a quota system is what we refer to it as in India is not allowed. The third and the fourth case, both were against University of Michigan, and these 2 also had similar verdicts. The fifth case was sent to a lower court, and it was the same, Fisher versus University of Texas, and it was the same case that was then brought up to the Supreme Court again as the 6th case. Here, the majority was in favor of what Lemon calls a soft-edged version of affirmative action, which basically relies on the judgment of the admissions office to use race appropriately while considering an application. And now we have the most recent case, as Meenakshi mentioned, which is the SFFA, which is Students for Fair Admissions versus Harvard College. And in this case, Harvard is accused of discriminating against its Asian American candidates. Lemon's paper seems to suggest that the current makeup of the court is such that it could lead to policies that aren't really race conscious. And he says that this particular case can actually be decisive in this long-running battle between meritocracy and diversity. He then goes on to talk about James Conan Bryant, who became the president of Harvard in 1933. He believed, Conant believed that standardized intelligence tests were the way to attract outstanding public students, regardless of their socioeconomic backgrounds from all over the country. So with this agenda, he made SAT a critical part of admissions for graduate and professional schools. So SAT is a kind of standardized intelligence test in the US. However, he was mistaken in believing that SAT could create a classless society. And Lemon argues that it instead introduced the word meritocracy, which is often correlated to as being deserving. So meritocracy is correlated to deserving. What it also did, according to a paper written by Davis and Havinghurst as a reply to Conant's policy, was that it created a strong cultural gap for pupils of various lower social economic groups. It was around the 1970s, so around 40 years after the SATs became a critical part of admissions, that various cases on reverse discrimination started to build in the US. Lemon then goes on to talk about who he calls the diversity detective. So he talks about David Oppenheimer, who is a professor at California University, and states that who states that everything about affirmative action and the law in the US hinges on diversity. So the reason they want to give affirmative action, and the only reason so far, has been diversity. And this is because of Justice Powell's decision in the Baki case. It's only to create an intellectually enriching environment, but not to address racial discrimination in the society or recognize the historical debt that the country owed to the Black people of the country. So Oppenheimer starts tracing the source of diversity, because he felt that if he knows why diversity is the only reasoning, he can unearth something about race, education, law, and get a better understanding of it. While tracing this, he realizes that even before the cases had started, the major reasoning, in fact, was to pursue diversity. It wasn't just a reason used by universities to justify affirmative action, but even far before the cases had started, diversity was one of the main reasons that various professors actually advocated affirmative action for. So he concludes by saying that diversity was such a persuasive explanation of how race can be properly considered in college admissions without even violating equality, that it almost became a blueprint for colleges across America. And Lemon argues that although this might be true, it may not be legally possible if there's a tougher problem that's posed to them, because then diversity wouldn't be reason enough for affirmative action. He then talks about Gabriel Starr, who is the president of Pomona College, who suspended the standardized admission test during the pandemic and said that affirmative action is in fact a great tool without which Black Americans would be handicapped, and that it's an educational policy, not just an admissions policy. And higher education is a means of battling social mobility, barriers to social mobility due to racial and economic injustice. He then ends the paper with Michelle Adams, who he says is an integrationist, and states that she was raised in an integrated neighborhood. So although she was a Black American, she went to a private school, which was progressive, and her neighborhood was also integrated. But Michelle Adams also believes that what is necessary is lowering barriers of entry. And she was of the opinion that explicit race consciousness might actually create resentment against the race, but there are various other kinds of interventions that are necessary. So what Lemon does is sort of takes us through various different opinions in America and colleges and people who play an important role in the admissions policy of various colleges to see sort of how the Harvard case would play out in the future. The next journalistic piece is, Meenakshi, you can change the slide. Thank you. The next journalist piece is NEET and the Illusion of Merit. This is by Salem Dharnadiran, and he talks about the idea of merit and how merit is almost abstract or even treacherous. He says that although it is considered as one's performance in competitive exams, what it doesn't talk about or doesn't factor in is caste-based disadvantages, parental exposure, living environment, the schools attended, or any other negative lived experiences of people. There are various research and studies that prove that competitive exams are an antithesis to the principle of merit. So studies and researchers have stated that students from rich families or wealthy families tend to have more of an advantage over those from a lower income family to get into Ivy League schools. Similarly, students who have parents that have graduated have a unique advantage. Other researchers tend to say that school marks, in fact, are a better indication of performance in the university and not really the standardized intelligence test scores. A research by Oswald also states that people from disadvantaged backgrounds who have managed to get into universities through affirmative action also tend to succeed because they seem to be more aspirational, determined, and also persevere for success. So the reason he argues that exams are an antithesis to the principle of merit is because entrance exams are trainable and they don't test the intelligence of a person. They're largely dependent on the number of hours that you spend studying and the kind of teaching you receive, the quality of teaching you receive, which of course would be far better for people from a wealthier background. Salem then has a sort of case study of Tamil Nadu. So the DMK government in Tamil Nadu recently passed a bill, I'm sure you guys know this, to abolish entrance exams for admission to medical colleges. Meenakshi, can we mute the person? Okay, I'm going to continue. And so they introduce a watered down syllabus for students of Tamil Nadu. Tamil Nadu ranks within top 3 of healthcare outcomes for healthcare outcomes due to various government investments. And they have the highest doctor population ratio, the best spatial distribution doctors. And this was achieved by abolishing entrance exams and introducing reservations and opening up multiple medical colleges or universities. So Salem thinks that Tamil Nadu should be made the best case example for other states to emulate. He then goes on to state that health, which is a state subject, and education is a concurrent subject. So the president should ideally give his assent. If NEET is mandated, it would be an infringement on the tenets of federalism. Unlike JEE, which only affects 3% of engineering students, NEET affects all medical students. And medical schools are funded by the state, while engineering students that the JEE covers are funded by the union. So really, if you continue, if the president doesn't assent to it and mandates continuance of NEET, then it would be a violation of federalism. I think with this, we can move on to the activity. Maybe what I can do is I can explain the activity first, and then we can have questions if you have any, so that you also know what you have to focus on. So we have 2 cases. One is the Howard case, and the second one is also a NEET case, but not the case about the new bill that was raised, but it's about the reservations in the All India quota for medical institutions. So this is the NEET case, which is Neil Aurelio Nunes versus Union of India. And on July 29th, the National Testing Agency issued an admissions notice, which provided for 27% reservation for OBC students, 10% for EWS students, under the All India quota, which is the quota for non-domicile and merit-based student admission for medical courses. Now, the claim in the court is that this violates the fundamental rights of the petitioners, and it amounts to reverse discrimination. What we need Group A, which I'm going to say could be the offline students, is to do is that they need to be the US court. You need to apply principles of the US legal framework to come up with a judgment for this case. So you would look at the facts of this case, apply the US legal framework, and as the US Supreme Court come up with a judgment for this case. The second case, Meenakshi, next slide, please. Thank you. The second case, as I discussed before, is Students for Fair Admissions versus Harvard College. Here, SFFA is a group of anonymous Asian American plaintiffs rejected from Harvard. And they've filed a lawsuit against Howard University for discriminating against Asian American applicants. And the claim here is that Howard's race-conscious admissions policy is unlawful and violates Title VI of the Civil Rights. And the petitioners seek to ban Howard and other colleges from considering or even knowing the race of applicants. So Group B, which will be the online students, Group B, which will be the online students, will act as the Indian court, apply the Indian legal framework to adjudicate the Howard case. We will give both groups 20 minutes to come up with a judgment, and then we will have 2 minutes of a similar pattern, 2 minutes of the judgment recitation, and then we can have 2 minutes of countering, discussions, whatever we think works best at that time. if you have any questions, please free to ask us that right now.
Any questions, or should we break into the breakout rooms?
Could the question be displayed once again so that we could take note of it?
You want to see the question again? Yeah,
Yeah.
sure. Absolutely. 1 second. This is for the offline group, which is group B.
Am I audible?
Yes, we can hear you.
Initially, Kalyani said that we are group A, so we are going to look at the US perspective, offline students.
Yeah, sorry, 1 second. I'm going to share that. Okay, so this is group A, which is for offline students, who will be the US Supreme Court, and this is your fact pattern.
Maybe you can show group B for a second. You could, everyone online could possibly screenshot it and keep it for your use, and then we can leave group A's question on screens during discussion.
We'll do that. So I'll just quickly move to group B, which is the online courses fact pattern. Online students, you can just take a screenshot of this, so then we move on to group A. Okay, I'm going to move back to group A now. So this is going to be on screen. And I'm going to activate the breakout room for.
Yeah, we can maybe convene around 1:05 or 1:10, depending on however long you take.
Sure.
I hope that was enough time for everyone. Maybe now we can start with the discussions part of the session. Would the offline students want to start with their judgment?
So am I audible?
Yeah.
So when we analyze this case in US Supreme Court aspect, I just want to state some principles. Like when we take results of University of California versus Party, the Supreme Court ruled that the university's use of racial quotas in admission process was unconstitutional, but the school's use of affirmative action to accept more minority applicants was constitutional in some circumstances. So, and also relying on this mismatch effect, like a critic or standard claims that artificially elevating minority students into schools they otherwise would not be capable of attending or discourages them and tends to endanger failure and high dropout rates for these students. So, for example, like about how the black college students rank in the bottom of 20% of the classes. So, black law school graduates are 4 times as likely to fail bar exams as are whites and interracial friendships, and are more likely to form among students with relatively similar levels of academic preparation. And thus, black and Hispanic people are more socially integrated on campuses where they are less academically mismatched. And also relying on the views of James Rachel, William Bennett, and the US Supreme Court itself addressed that the main provision of quotas is to get rid of discrimination. But this approach would also lead to the reverse discrimination of the individuals. So I would think like this quotas won't prevail according to this principles. And it's also unconstitutional.
Okay, thank you. Is there someone else who would want to add to that? Can you speak a little louder, please? Yeah, that's fine. Maybe you can continue.
Yeah. So I want to oppose one more point, saying that if we see it in a US perspective, US is a federal state. So because of it, the case as So it does not, it is actually unconstitutional because the central cannot force every state to follow this because federal laws and federal laws are different. And also in the states, there are 9 states which ban affirmative action. And to quote, I want to quote Court versus Coalition's case, in which the court has approved that the ban is the states can ban affirmative action policy. So it is up to the states whether to accept this or not, and the center cannot put such a rule against it. And one more perspective which I feel is necessary is reservation only actually adds up more complicated layer over the governance of massive territory. And this point is also quoted in the United States Supreme Court case, which is McGriff versus Oklahoma. So I feel if this case is seen in the United States court, then obviously it is unconstitutional.
Thank you so much. Thank you for your views. If there's anyone else who wants to speak, we can take that up, or we can move to the students who've logged in online.
Yeah, that's what we can do.
Okay, thank you. Is there somebody who wants to speak for the students who had discussed it in the break room?
Okay, I will start. I would like to state that the SFFA's claim on, having been racially discriminated, it amounts to challenge the Harvard's admission practices as an attempt to invalidate the affirmative action, but in the guise of preventing discrimination. The court would like to say that this judgment would not constitute to any sort of it would not cause any sort of damage to the affirmative action policies by the college as well as the government. And I would like to pass it on to my teammates to continue this.
I'd like to add to what Divyadashini said. So since we are looking at it from an Indian judiciary perspective, I believe Indian judiciary is all about granting equal opportunity to every sector of the society. So say that we remove the race classification completely from all application letters or all application forms, there might be a possibility that 90% of the students in Harvard might be from the Asian American community, which is not what the Indian judiciary strives for. So instead of picking sides wherein we give a judgment saying what you did is right, what you did is wrong, and instead of giving a very strict interpretation, I would suggest that maybe we can give some guidelines wherein we can classify the Asian American community as a minority and say that every college is supposed to have so and so much percentage of seats reserved for them. So that way they wouldn't feel that they're being discriminated unreasonably. So just like how we have caste-based reservation in India, from the US perspective, we can maybe try to implement a race-based reservation. That way everybody has equal opportunity at fair admissions. So this was what we discussed in our breakout room, and I'd ask my other team members to add to it.
Is there anyone else who'd like to add to it from the breakout room?
Yeah, our Indian constitution, usually we support the growth of even the minority people. So I would like to state that the Asian American people, when compared to the native people, they are considered to be the minority people. So if we consider the articles 15 or 4, we have a statement that where we have special provisions even to support the backward class peoples. So we could use that article to support out and give special provisions to the Asian Americans.
Thank you. Thanks for your input.
Yes, adding on to that, we'd also like to criticize Harvard for imposing de facto Asian American quotas. Thereby, that would be the conclusion of my judgment.
Thank you. Thank you so much. We can maybe use the rest of the 2 minutes to either question the other team's judgment or discuss if you have any other follow-ups for the opposing team.
I've got a gentle point to add upon. So throughout the time we've been discussing about affirmative action, there's been one point that we need to reflect upon, which is the creamy layer concept. And that has been the basis for which they've actually brought in this 10% economically weaker section reservation, and the case is it's sub judice before the court in the Youth for Equality versus Union of India. So despite we having a caste-based reservation in India for about 75 years, that is since we got independence, we've not been able to achieve its motive. That is, still many people tend to be below the poverty line, although the main motive of reservation is not to alleviate poverty, but still education is intended to alleviate poverty and to give economic independence to people. And if there is no adequate, this clearly indicates that there hasn't been an adequate representation for people in education in India. So I believe personally that this caste-based reservation system hasn't achieved its motive or it hasn't achieved its own perspective of bringing in good amount of representation of people, especially the depressed, so-called depressed caste in India. And therefore, we need to bring in a composite type of affirmative action so that we can balance both the weaknesses of this caste-based reservation that's been prevailing in this system, and at the same time we can alleviate we can bring in better amount of representation. So this was my point. The concept of creamy layer is a big question, and we don't have adequate policies to identify who the creamy layer are, and that is where the lacuna of reservation is in India. So that was one thing which I wish to reflect upon.
Thank you for your comment, Prakriti. Is there anyone else who wants to add or respond to Prakriti?
Just one quick point, Kalyani, maybe students can also think about it.
Yeah.
Is that, yeah, while what the US Supreme Court did was strike down, right, the quotas that were the 27% for OBCs and 10% for the economically weaker section. Just one thing to think about is, yes, maybe quotas are unconstitutional, but could there have been other ways to ensure that student body is diverse in medical colleges? Yeah, that's
yeah. Thank you. Yeah, so I think the discussion so far has been great. And when we did this activity ourselves, we reached similar conclusions where we did think that affirmative action could be allowed through strict scrutiny rule, even in the US, but they might have overturned the quota system. But maybe they could have also, like Meenakshi mentioned, an alternative system could be set a target, for instance, to achieve a certain number of representation in the university itself. Similarly, even for the Indian Supreme Court case study, we reached actually a very similar conclusion. And we also think that, of course, that race needs to be considered in the admission process. But one possible point that we did think of was who should classify, I mean, who will have the responsibility to classify which races would then be considered in the admission process. So that's one point that we could possibly think about. amongst ourselves maybe later. With this, I'd like to conclude the activity and invite Professor Sidharth Chauhan, who is an assistant professor at Nalsa Law University. During his master's at the University of Pennsylvania Law School, he concentrated on constitutional law and legal philosophy. Prior to being part of NALSA, he also worked as a law clerk in the Supreme Court of India. After this, he taught courses on political theory, statutory interpretation, and legal methods at NLSIU Bangalore. He then joined NALSA and is a faculty advisor for the public policy lecture series, the lecture series on constitutionalism, and the NALSA Student Law Review. Professor Chauhan has also been involved in the promotion and organization of competitive debating at several Indian colleges, and his writings have appeared in publications such as the Social Legal Review, the Indian Express, and Frontline Magazine, amongst others. Professor Chauhan, the floor is now yours. And Professor Chauhan is going to speak on affirmative action and merit in education.
Okay, thanks for inviting me. I hope our audience can hear me, both the offline and online group. Obviously, we cover the discussion on reservation policies as part of a larger theme of anti-discrimination law in our coursework. And I'm sure the students at TNDALU are also either have already done a course on constitutional law, or some of them are about to do it if they're in the early stages of their study. So I was listening in to the presentations that were made about an hour and a half ago. I joined around 11:55, so I might have missed the first 10 minutes. But I did listen to the student responses as well. So it seems that the group is a little mixed. It appears that there are students from all batches. It doesn't look like only older students or younger students. So I'll try to keep my comments in a slightly more general frame so that everybody is able to navigate through them. And if you have specific questions or concerns, then hopefully we should be able to respond to them. So before I just say what I think will happen with the two cases that have been chosen by the CLPR team, I just wanted to make a few points about this domain and in general, and just offer a couple of clarifications based on some of the comments and remarks that I've heard in the last hour or so. So the first point I want to make is, of course, about the ideas of merit and how they are socially constructed ideas and what we should do going forward. The second point is actually was mentioned briefly, but I think not fully fleshed out in the discussion, which is that reservation policies are only one form of affirmative action. And there are other possibilities, other structural as well as specific interventions which can be made to address the interests of minority and disadvantaged groups. The third point, of course, is to go back to the general justifications for affirmative action and to ask which of these general justifications is more relevant going forward. And lastly, to talk about the role of reservations or affirmative action from in the private sector, which is a theme that has been spoken about a lot, especially in the literature in sociology and economics. But unfortunately, law students and the legal curriculum have not given adequate time and attention to the question of the private sector's role in ensuring questions of social justice that they're pursued. I beg your pardon. So those are the four broad points which I just want to briefly touch on. And then I'll just say something about the two case studies which were chosen for you. So on the first idea of merit, of course, I think Meenakshi took you through the basic argument made by Michael Sandel in his book, The Tyranny of Merit. But it's obviously a much older argument that when we look at the construction of social or cultural capital, obviously we cannot assume that 18-year-old students entering an undergraduate program would have the same degree of social or cultural capital. Depending on our caste location, depending on our parental status, depending on the kind of domestic environment that we got, each of us might actually possess a different kind of social and cultural capital, which prepares some of us for the rigors of higher education and, of course, puts others in a more difficult spot where they have serious difficulties in coping with the demands of the coursework. But what I wanted to say is that if you look at the idea of capital more generally, generally in public discourse, when you step outside the confines of educational institutions, the word capital is understood in a very narrow way. Most people understand capital as financial or economic capital, And generally, a reference to differences in capital is understood as arguments about wealth-based inequality or differences, let's say, in land ownership or ownership of businesses, which are the more obvious implications of using the word capital. But I think much of the literature in the social sciences now for a long time has been saying that we should not understand the word capital in that narrow sense. If you're talking about questions of inequality and you want to talk about them seriously, then economic capital is only one marker of difference. We must obviously turn the attention towards social and cultural capital, but there's also the question of unequal political capital. So I think the question of inequality has to be seen in an integrated way by looking at social, political, and economic systems together, rather than splitting them up and separating them into silos without really understanding the interactions between them. So when we do talk about the differences that might be there at the stage of seeking admissions to an undergraduate program, a postgraduate program, or for that matter, even a doctoral program, the basic argument is that what kind of policies can educational institutions or governments design which ensure that groups which have historically not had access to formal education, or groups whose viewpoint or interests have not been fairly represented in media and popular culture, also then get an opportunity to enter these institutions, right? Now, of course, we can frame this issue in a legal sense by talking about whether the main intention is to compensate for historical backwardness, or whether the main intent behind these policies is to ensure equitable representation in the present. And a few people, of course, would say that equitable representation in the present is far more important. And the question of compensatory discrimination, as Professor Mark Galanta called it, is not so important. So that's, of course, a view that many of you would be hearing about and reading about in the popular press. Now, I have my own take on that, but I think it's important for us to say that social and cultural capital is accumulated in a way that is sometimes different from the accumulation of wealth-based and economic forms of capital. So it's quite possible that you might have people whose families have succeeded in small businesses, or who have parents who have, let's say, become civil servants. But it doesn't necessarily mean that the children from that household are actually as prepared as their counterparts from dominant caste groups in terms of accessing college or specialized education. And I think that's a point which we are not fairly conveying in the public debates on these questions these days. There's also the correlation with political capital, because remember, there are certain groups which may be underrepresented when it comes to public universities or civil services or government jobs, but they might in fact be influential on the electoral side. So especially when we look at the issues of OBC reservations and the demand by several intermediate castes for OBC status, and there are multiple examples of that. I mean, I'm not so familiar with Tamil Nadu, but certainly in Andhra Pradesh, there is the Kapu group. In Maharashtra, there are the Marathas. And of course, in my home state of Haryana, there are the Jats, who have actually been dominant in the agrarian landscape in terms of land ownership, in terms of representation in lower end government services. But when it comes to the question of their representation in higher education or public employment, their numbers are low. So the question is, should we be including these groups in the OBC lists at the state level when there is a pattern of political dominance which these groups have developed? But on the markers of educational backwardness or economic backwardness, they might be closer to the groups which were meant to be covered by the reservation policies. So which is why I think you have to take a more interdisciplinary and interlinked view of differences in social, economic, and political capital to be able to make sense of these arguments. The second broad idea, of course, is the fact that affirmative action is not limited to reservations. We might tend to believe that quotas or reservations are perhaps the only or distinctive way of doing affirmative action in our context. But even if you just look at administrative policy in a more holistic way, whether it is in India, US, or any other country, you will find there are many other methods of delivering affirmative action as well. So obviously, those of you who know the text of the Indian Constitution know that at the moment, our reservation policies are explicitly laid down in 3 domains: higher education, public employment, and elected bodies, which is actually the focus of my own research, but I won't say much about that. But within these 3 domains, you have very explicit provisions which appear in the text of the Constitution, which enable both central and state governments to design policies, usually by executive orders. And of course, in some cases, there is a state and central level legislation. So by and large, the legal analysis has been limited to these provisions. 15.4, which was added after the Champakam Dorai Rajan case in the early 1950s, which is the main provision for educational reservations. 16.4, which is, of course, the main original provision for reservations dealing with the representation of backward groups in government jobs. And of course, there are provisions for electoral reservations in Article 330 and 332, which are at the moment limited to the Parliament and the state legislatures, and some specialized provisions for reservations in local government, which were added as recently as 1993. Now, without getting into the details of these constitutional provisions, we must also be aware of the fact that apart from this explicit constitutional language, there are other options as well. For instance, targeted scholarship schemes. Both the state governments and the central government in India obviously has a broad range of targeted scholarship schemes, which are responsive to the identity of the applicant, which in fact consider the social background or the financial background of the applicant, and then try to subsidize college education by a reimbursing fee. In fact, you have specialized ministries which are responsible for dispersing and delivering these scholarships. The Ministry of Social Justice and the Ministry of Tribal Affairs are examples at the central level. And then you have counterpart schemes at the state level, which have also been in place for a long time. Similarly, an idea which is not very well developed in India, but is certainly well developed in the US, is the idea of loans being given, especially to minority business owners who may otherwise find it difficult to raise capital in the banking sector. And through targeted loan programs, which are covered by the federal government initially and now with several states, you actually create the possibility for groups which have historically not had fair representation in businesses to try and invest capital and develop their economic potential through that. There's also the third possibility of government contracts, which is again something which is not always laid out explicitly in constitutional provisions, but through routine administrative regulation, you can of course create a policy of preferential government contracts where applicants who belong to minority or disadvantaged backgrounds might be given preferences based on questions of historical justice. So these are examples on which legal research has actually not focused on as much as it should. There is certainly work in the field of economics, especially led by Professor Sukhdev Thorat, who was earlier at JNU, and his team, which has looked at how these other alternative mechanisms of affirmative action have worked. And I think it is time that legal scholars also pay more attention to these measures other than reservations, which may actually also be working and might actually be having a far deeper structural effect on questions of representation and especially access to education, which is the focus of today's workshop. The third set of ideas which I had, of course, are something to do with justifications for affirmative action. But before that, I've got something else in my notes about the alternatives to reservation. So obviously, there is a question of reservation at the stage of admission to educational institutions. There's a question of reservations at the entry level in government jobs. And of course, there is a question of reservations especially for scheduled castes and scheduled tribes, when it comes to elections to the Lok Sabha and the Vidhan Sabha. But these mechanisms are also being pushed in different directions. For instance, there is now a well-established jurisprudence on reservations in promotions. So I just wanted to correct the student who said that, because even though the Indira Sani case said that there ought to be no reservations in promotions, Article 16(4)(a) was added in 1995 with the Parliament adding language which says that you can have reservations for promotions, especially for scheduled caste and scheduled tribe employees who are in public services. Now, there's been a complex web of litigation around reservations and promotions since that amendment in 1995, including a constitutional bench decision called M. Nagaraj in 2006, which has in fact upheld reservations in promotions. But the courts have applied some qualifying criteria such as counterbalancing considerations of efficiency and proportionality when you design reservations in promotions. In fact, the most recent litigation in the Supreme Court on this question has focused on reservations in promotions. So if you want to pass the civil service exam, you have to read all those judgments and get a good sense of that. But apart from reservations in promotions, which is limited to the employment context, there's also the question of reservations in faculty positions, especially if you look at some of the most well-known educational institutions in India, and I'll include mine in that, whether it is the National Law Universities, whether it is the IITs or the IIMs, or for that matter, even the central universities. A serious database scholarship will tell you that even though SC, ST, and OBC reservations have been implemented at the student level, you generally don't see much representation for these groups when it comes to faculty appointments. And the very simple device that is often used to block the implementation of reservations at this stage is to say that not sufficient candidates were found, or amongst the people who applied, they were simply not good enough for the requirements of the job. And this is a problem which I think has not been heavily litigated, but certainly deserves more attention and serious scholarship, because there has been work recently which has shown that at least amongst the IIMs, which are considered to be the best business schools in India, the representation of scheduled castes and scheduled tribes in the faculty is minuscule. It's not even 2%, which was shown by a survey done recently. For that matter, if I look at the network of institutions that I am part of, amongst my 52 colleagues, I think there's only one person from the scheduled caste background and maybe 3 from the OBC background. Now, the question is, how do you sort this out? Because when it comes to the applicable legislation or the applicable government orders, the policies are there, which require you to implement these reservations. And obviously, you do it because student admissions get a lot more attention. More people are likely to litigate against you if you don't comply with the policy. But when it comes to faculty appointments, there's literally no discussion and literally no scrutiny on these questions. And I think it's a problem with most central universities as well. It's only a few state universities where representation for historically disadvantaged groups has actually improved. The other point I just wanted to quickly make was about proactive steps that can be taken in the political domain. For instance, can we think about measures for intra-party democracy? Can there be more equity in candidate selection when parties field candidates? Can there be alternative models like proportional representation, which would ensure that groups, despite having smaller numbers, will have fairer representation in the legislatures? And of course, there is the older argument of separate electorates, which Dr. Ambedkar had made, which he thought was an important safeguard for the depressed classes. Now, those are all issues which are somehow linked to the past, but also have raised certain challenges for the future of Indian democracy. But since we are not really focusing on political reservations, I'll just flag that and move on. Now, coming to the larger justifications for affirmative action, I think we've already surveyed those ideas in the presentations which were made by Meenakshi and Kalyani. You could say one set of arguments favoring affirmative action is focused on ideas of historical justice, which suggests that all of us have a collective responsibility to recognize wrongs committed in the past and to address those wrongs. So one could say that reservations which are based, let's say, which are tailored towards the scheduled caste communities or the scheduled tribe communities are more or less a reflection of ideas of historical justice, because there is more than sufficient evidence to show that these groups were structurally excluded from participation in the mainstream economy and society over time, right? And of course, there are differences amongst the various castes, which often get classified as scheduled castes and scheduled tribes. So I think there is not much debate or disagreement in our political spectrum about the utility and need for scheduled caste or scheduled tribe reservations. The real debate at the moment is, of course, about OBC reservations. And the Derek Nunes case, which is being discussed right now, is only one example of many other challenges and questions which have come up in the context of OBC reservations. One constant thread that you hear in this line is that, look, but expanding the reservation pie to expand the OBC lists is not really addressing arguments of historical justice. It might have more to do with concerns about equitable representation in the present. But if the same group has not suffered the kind of social stigma or historical discrimination which have been faced by the Dalit and Adivasi communities, why should we extend that, let's say, to agrarian caste groups or intermediate caste groups, which are otherwise not so oppressed? So this creates a serious problem of pitting disadvantaged groups against each other, which is also a very conscious strategy which is sometimes used to not only question the rationale for reservations, but to also start undermining it in the long run. And I personally think, I think many others have made the same point, that the deliberate emphasis on OBC reservations is also to create a public sort of opinion about the misuse of this policy, rather than the targeted and strategic use of this policy. But that's a political point and not so much a legal point. So my concern is that rather than clarifying the criteria for reservation as relying upon historical justice, if we do start talking about equitable representation amongst communities, then we might also lose the emphasis, the original emphasis which was there on the fact that the group needs to have suffered social stigma or discrimination for them to be included amongst the groups that now need to be represented in the public domain. And I see the current litigation as part of that larger conversation. For instance, it's a classic conservative strategy to put two disadvantaged groups against each other, right? And that's actually happening in both of these cases, whether it is the Student for Fair Admissions case in the US or even the NEET controversy in India. Now, to be honest, from a legal point of view, if you ask me, should the OBC reservation be implemented in the context of the All India quota in NEET? Well, legally, the court will more or less have to uphold it. And I'll tell you why. Because OBC reservations have already been upheld in the context of central educational institutions in the Ashoka Kumar Thakur case in 2008. OBC reservations at the level of central government jobs have already been upheld in the famous Indira Sahni case, which all of you must navigate through if you want to understand the law of reservations. Even if you can't read the full judgment, at least the judgment by Justice B.P. Jeevan Reddy, which more or less captures the questions and the major ideas around that issue. But so given the precedent and given the sort of political relevance of the OBC lists, I have no doubt that the OBC reservations are going to be upheld by the Indian Supreme Court. There might be some debate about EWS reservations because EWS reservations were an addendum to the original recommendations which were made in the early 1990s. And of course, it is the BJP government which implemented the EWS reservations only 2 years ago. So there might be some room for debate there because once again, rather than concentrating on the lack of social or cultural capital, the argument for EWS seems to be based on income limits. And the central government seems to have announced a very absurd limit of 8 lakhs to decide whether someone or not belongs to the EWS category, which basically means that someone like me, who might belong to a dominant caste, can claim that their family income is below 8 lakhs and claim admissions under EWS, which is obviously a misuse of the policy. So I think on EWS, you might see there is a separate challenge pending against EWS reservations. And if a fair bench hears the case, you might see a back and forth and some serious scrutiny of the EWS reservations. But with respect to the 27% reservations for OBCs, I think there's no doubt that the court is going to uphold it. Now, the question is, what sort of impact will it have on the educational admissions in other sectors as well? So while central universities have in fact implemented the OBC reservations over the last 13 years, and they in fact expanded their seats to ensure that the number of general seats did not change, in many places, the rapid expansion of the infrastructure has not been possible. So from an empirical point of view, many universities and colleges will have to prepare not only to accommodate OBC students, but also to increase their seats so that there is a smooth transition towards this policy. So I have no doubt that this will be upheld, and more or less institutions have to make changes in accordance with the needs of the time. But the issue which is the red herring in the room, of course, is faculty reservations, which I did flag for you. And I would urge you to think about that a bit more thoroughly after this session. The last point I wanted to make is that apart from the question of focusing on historical justice or looking at distributive justice through the lens of the present, which is the major ideological way of looking at this area, we must also think about whether or not reservation policies or other forms of affirmative action should create obligations for the private sector. Now, at the moment, there are 2 provisions in the Constitution that do explicitly include the private sector in this area. Some of you have in fact mentioned it. Article 15.5, which talks about the obligations placed on private higher educational institutions to not only to reserve seats for scheduled caste and scheduled tribe candidates, but also for other backward classes. That got litigated, but now it is pretty clear that policies can be made to enforce this. And of course, there's Article 21A, which was added in 2002. I think that was the year I started college, where effectively the text of the Constitution now says that there ought to be a right of free and compulsory education for children in a certain age group. So the Right to Education Act, of course, which comes in 2009, is a legislative enforcement of Article 21A. There is a secondary debate about why the right to education is limited to class 1 to 8. Why could not it have been from preschool to class 12? But that is more at the level of implementation and policy. So we already have 2 constitutional provisions, Article 15.5 and Article 21A, which have brought the language of fundamental rights closer to enforcing obligations on private parties. But we don't have counterpart provisions for reservations in private employment. And much of the research in anti-discrimination actually is drawing your attention towards that sector. So especially many studies which were published under the tutelage of Professor Sukhdev Thorat, especially in the Economic and Political Weekly in the late 2000s, were focusing on discrimination in the private sector, where through personalized empirical studies, they were able to document patterns of discrimination in the housing market, in the private employment market, and they came up with very rigorous data to show that there might in fact be a case for affirmative action in the private sector. Now, for obvious reasons, I don't think there's going to be much action in that direction. At least with the current structure of Indian politics in India, I don't think it's happening. Especially if the current ruling party in the center remains in power for the next 30 years, which is their plan. I don't think there's going to be any discussion about reservations in private sector. But you do see a clear strategy of them trying to dilute the policy of reservation, especially with the EWS policy choice. So lastly, on the two cases that we've discussed, on the students of fair admissions case, please remember that in the US, you have a very long history of groups which are deliberately set up sometimes to initiate litigation. So they're different from genuine civil society groups, let's say like CLPR, which are trying to promote education and have a sort of long-term intervention or engagement with their field. But there is a constant practice in the US of setting up interest groups which will specifically litigate a particular issue. And a few years later, you have no clue who was supporting it, who was funding it, and where it went. So the Students of Fair Admissions, I'm sorry, is one of those groups. It's actually been set up deliberately to question the reservation policy because at the moment, sorry, I beg your pardon, the affirmative action policy, because at the moment there are 6 conservative justices in the American Supreme Court, thanks to Donald Trump. And most of these judges, in fact, 2 of them, in fact, don't deserve to be there. They were just there because they had a favorable precedent. And most likely what will happen is that they will hear this case and they will actually give the relief which this group is wanting, which is that race should not be an explicit category at the time of making admission decisions. But look at the absurdity of it, right? A country which has had a long history of slavery, a long history of discrimination against immigrants, is now pitting an immigrant group against a group which has historically faced racism. So effectively, it is being set up as a clash between the interests of studious Asians, which is mostly Indians and Chinese, and of course, the African-American group, which is facing disadvantages at a multi-layered level. So this is one of those cases which is just meant for nuisance value. And the objective, of course, is that once they get a favorable order, they will say, look, but it's a minority group which went to court and questioned the way in which Harvard was conducting its admissions. And then they will use it to mount stronger challenges against affirmative action programs across the country. That's clearly part of the strategy. And one can see it from a long distance away, right?
Sorry, Professor Chauhan. Yeah, we just need to sum up now.
Yeah, I'll just close up. I'll close it up. So on the NEET issue, I think I've already kind of made my prediction. The 27% OBC reservation is going to be upheld. I mean, any judge who reads precedents obviously will be bound to uphold the previous decisions in Indira Sani and in Ashoka Kumar Thakur. I don't see any room for wiggling away or making any exceptions from that. But on the EWS question, I think because there's a separate constitutional bench that is pending, there is room for debate. And one should argue that reservations are primarily about addressing differences in social and cultural capital and not so much economic capital. But that's just a view of some people. You might have government lawyers making a more persuasive case, especially when judges are worried about their post-retirement prospects. So you never know how they will decide. But given the pattern of what the court has been we've been doing in the last 3 or 4 years, I'm not too sure. But at least legally, I would say EWS reservations rest on a much weaker footing. But with OBC reservations, though there are arguments about dominant groups being included in some states, I think legally the answer is pretty clear that the court is going to uphold it. Right. So I think that's pretty much what I had on paper here.
Awesome. Thank you so much, sir. That was actually a very interesting talk and sort of brought the discussion together. And you also highlighted some very interesting points that talk about the need for interdisciplinary view while looking at beneficiary groups, and also other structures or measures that are needed for increasing representation. Now, if students have any questions, maybe we could do a minute or two quickly of any questions that you have for Professor Chauhan. Feel free to write the questions in the chat box if you think that's better.
Or if somebody wants to speak, you can just go ahead. I mean,
If somebody is speaking from the law school, we can't hear.
Yeah, if you're asking a question or saying something, I couldn't hear you. I'm sorry. You'll have to either speak into a mic or come closer to the screen.
Yes.
I can hear you partially. Please speak up. Yeah.
Yeah, so I have a general question. As per you, do you think in next 10 to 20 years, can this reservation be demolished in India in after 20 years? Will that state come? There will be no need for reservations in India.
I mean, nobody has seen the 22nd century, but I think 10 or 20 years is not enough time, because see, the main argument here is not just that people will get better jobs with elite education, or people will be able to enter parliament or state legislatures. It's also a question of how social attitudes have to be reshaped over time. So I don't think it's going to happen over a 10 or 20 year period. I mean, to be honest, given the sort of electoral implications of reservation policies now, especially with OBC reservations in many states, I think we have to live with this policy and make the most of it and refine it as we go along. And I think it's going to last for a much longer time. I mean, possibly if some of you live to 100, maybe then we can reevaluate it. But that's just my opinion, right? Please feel free to disregard it. I mean, who knows? There might be another pandemic. There might be a civil war in 60 years from now. So who knows what's going to happen in 2100? But if we continue with our current constitutional structure, I think reservations are pretty much a central part of it. And even, let's say, I mean, even though I was being a bit critical, but even the right-wing parties have accepted it. In fact, the BJP had initially opposed OBC reservations in 1991, which is why they destabilized the VP Singh government. But now they are the ones who are aggressively pursuing OBC reservations in many domains. So within 30 years, there is the opposite sort of stance taken by the current ruling party. So that's it. I mean, I don't think there's going to be much disagreement at the electoral level.
Maybe we can take this one last question that Divya Darshini posed in the chat section. Yeah. She wants to ask you what you think about intersectional discrimination and how would that play out with respect to affirmative action. Yeah.
So, Divya Darshini, to some extent, intersectional reservations have already been included. In fact, that's the example I didn't develop. If you look at the reservation provisions in local government, which were brought in through 243D and 243T, if I remember correctly, they deal with the reservation policies in panchayats and local bodies. You already have an intersection between gender and caste and gender and tribal identity, respectively. And if you look at the way in which the disabilities legislation has been amended, I think earlier the quota used to be 3%, now it's 5%. So in effect, it does operate intersectionally because it tends to be spread across gender. But yeah, if you complicate the categories further and say, look, are we looking at gender, caste, regional background, sexual orientation altogether? I mean, that of course may create practical and implementational issues. But I think a beginning has already been made in this direction during Narasimha Rao's time. And 243D and 243T are in fact good examples of that. Because the gender-based reservations work already in an intersectional form, that you have 1/3 of seats in the Panchayati Raj institutions, which are meant for women, and these 1/3 are intersecting with the general SC and ST seats. So I think even with the educational institutions which have brought in gender reservations, that's how it works. But gender reservations are not counted for the purpose of the 50% cap, which the courts have created. The 50% cap is only meant for the, I think, the vertical categories, SC, ST, and OBC. So reservations based on gender or disability are not counted. In fact, I can give you an example from Nalsar. Our own management was, in fact, historically avoiding OBC reservations, and they had only implemented them in the Telangana seats. But the state government has made it very clear that you must implement the OBC reservations across all categories. And we also have, of course, reservations for women and persons with disability. So in effect, it becomes an intersectional reservation. But of course, if you take the theoretical literature very seriously and look at not just 2 or 3 markers of discrimination, but 4 or 5 markers of discrimination, then the administrative design is going to get a bit more complicated. Then maybe a quota system may not be the best way to resolve that.
Excuse me, sir.
Yeah.
So there is this one question which has been haunting me for a very long time, and I think right now I think you can clear my doubt. We have this caste-based reservations in India for education. That's fine, and I completely agree with it. So why do we again bring in the concept of caste-based reservation in the concept of employment? Once everybody is educated, now the opportunities which are available for them is more. Like when you come to employment, everybody is educated. Like the ones who get employed are the ones who are educated, mostly in a general view. So again, why do we bring, like when everybody is educated, why are we bringing the concept of caste in reservation when it comes to employment?
Yeah. So good question. So Dr. Ambedkar tried to answer this question in his writing in the 30s itself. In fact, he has an excellent book called What Congress and Gandhi Have Done to the Untouchables, published in 1945, which was actually a criticism of how the Congress had forced him to leave his demand for separate electorates, but that is for the elected bodies. But he also has a discussion on this precise question that you're asking me, that if we are seeking better representation, of course, he's speaking from the viewpoint of the Mahar community. So he says, if we are seeking representation in the universities, why are we also seeking representation in government jobs? So his argument is that even if formal markers of representation tend to work at the educational context, it doesn't always dissolve the social prejudice or the barriers which exist at the higher levels as well. So the fact that more people from, let's say, the Dalit community are getting educated may not necessarily mean that a higher proportion will also get access to government jobs and then make progression throughout. So his argument is that measures for representation have to be looked at in a holistic way. In fact, he created a memorandum around the time he was the labor minister in the colonial government, where he looked at representation in education, representation in employment, representation in legislatures, and there's also a crazy idea about separate settlements, which of course got the beef of the Hindu Mahasabha, which were all written in the same book. So if you look at Ambedkar's defense of reservation, especially for the historically disadvantaged groups, he's seeing this as an integrated package. And the real argument for that is not that individuals have to gain or improve their lives through access to these resources, but the kind of symbolic benefits and the incubation of leadership that will happen for that community. So the argument is that, let's say, if I come from let's say a scheduled caste community, and let's say my father is already a civil servant because he got the benefit of that policy 30 years ago. So your argument would be, then why should I get that benefit when I complete my education and then I apply for a government job? Because then I might actually have a better chance of becoming a civil servant in comparison to a dominant caste peer. So the argument is that unless these benefits percolate and they are reinforced over a certain period of time, the societal prejudice will keep creating barriers at different levels. Now, again, there is social science evidence which is brought both in defense of employment reservations and also against employment reservations. There are people who say that employment reservations are not needed because they require service to the people. It's not necessarily about receiving, which is the case of education. But Dr. Ambedkar, in fact, has a very nuanced and elaborate response on this question. So you don't have to agree with it, but there's definitely an argument that caste-based discrimination does not stop with educational institutions alone. In fact, in the employment context, it has been shown, and I think Professor Gopal Guru has done some serious work on this question, where he's shown that even high court judges and legislators who come from Dalit communities are still not treated as equals by their colleagues and by their peers. There's a great example from his own department where he said that when an upper caste professor got appointed, I don't want to name a particular community, but when an upper caste professor got appointed to his department and found out that the same quarters had been occupied by a Dalit professor previously, he actually got the quarters purified. And this is happening in JNU, right, which was considered to be the most progressive institution in India. Now, of course, everybody calls them anti-national, but that's a different debate. So what I'm trying to say is that for Dr. Ambedkar, the affirmative action policy is not a one-step intervention, right? He was talking about expanding primary school networks. He was talking about government scholarships. He was talking about opening up schools in rural and tribal areas. And then, of course, for him, access to public institutions became the main focus of his policy that he drafted in the Constituent Assembly. He, in fact, did not really argue for reservations in the private sector. That argument has actually come more recently in the last 10 to 15 years, especially by economists like Sukhdev Thorat, and the group that has worked with them, right? But again, it's not a popular argument, and I don't think it's going to go very far.
I have one last question, sir.
Yeah, sure.
General question. So, do you think our Indian Constitution will be a catalyst in making India a developed country?
Okay, so by developed, do you mean economic development or social development?
So basically, sir, India is now currently a developing country.
Yeah.
So, do you think Indian Constitution will be a catalyst in making India a developed country?
No, but I'm just asking a further clarification. By development, I mean, are you thinking in terms of GDP growth, better infrastructure, better finance, or are you also thinking about social development?
Social economic.
Okay, yeah. So to be honest, if you look at the existing design of our constitution, be it the fundamental rights or be it the directive principles, I think both social and economic development were priorities at the time of the drafting of the constitution. And I think some of you who have already studied constitutional law might have come across this book by Granville Austin on the framing of India's constitution. For those of you who haven't, I would really recommend that you read it. Especially when you're a current law student, you know, a lot of things make much more sense if you read this commentary on the Constituent Assembly debates. And he actually argued that at the time of the framing of the Constitution, there were three broad objectives which were pursued. One was, of course, building national unity, because the British Indian provinces and the princely states had to be integrated in the context of partition. The second was, of course, building democracy, which was to put in place a system of representative democracy where all adults could vote. Remember, historically, all adults could not vote. And even the Constituent Assembly was chosen through limited elections, where only about 10% of the adult population, in fact, had voted, because voting was limited based on property and education. And the third goal, of course, was social revolution, which was to design policy which would redress economic and social differences in the population. So at the time, the strongest focus was on agricultural land reform, and of course, the question of reservations in employment. Those were the two issues that were discussed more thoroughly in the Constituent Assembly. But I think if you go back to these general principles of building national unity, of building a strong electoral democracy, and also pursuing social revolution, I think those are still pretty much the founding ideas of the Indian Constitution. And if we renew our commitment to these ideas with each generation, then I'm sure at some point we might be able to describe ourselves as socially or economically developed. But unfortunately, at the moment, the focus seems to be a bit more on narrow parameters of economic development and not so much on social development, which is why I asked you that question. So we have to wait and see. But certainly, the Constitution has the conceptual tools and the policy choices which can make us a developed country.
Thank you, Professor Chauhan. Maybe with that, I think it's time we close this session.
I think there's one question in the chat.
Sure. Would you, of course, yeah, you can.
S. Chetan Kumari, who is asked, don't you feel reservation is leading to discrimination in certain circumstances? For example, the age limits for attempting the UPSC exam. For general castes, I think the gap is 32, and for the SC/ST and SC/ST groups, it's now 35. So isn't that a differential? So, I mean, if you look at discrimination in that literal sense, yes, there is substance in what you're saying. Why should people belonging to certain groups be given more time to attempt the UPSC exam? But I hope part of that question was answered earlier when we spoke about the differences in social and cultural capital, because your ability to cope with competitive exams, your ability to enter elite institutions, and even, let's say, I mean, the UPSC is the most competitive exam in the country, right? Even more competitive, I think, than the medical exam or the engineering exam, simply in terms of numbers. So I think it's pretty much the same argument that, that because people from certain communities have historically not had access to education, many of them might be first-generation learners, others might be second or third-generation learners, but they don't get the same kind of institutional and intergenerational support structures that people from dominant castes might have got. So hence a policy choice is made to give more time. So I think it pretty much ties up with the original logic for reservations. It's only one example. Should it be seen as discriminatory? Well, I mean, there are groups like Youth for Equality who describe everything as discriminatory. who say that, dominant castes are being forced to give up this, give up that. I mean, according to them, we should go back to zamindari or the pre-independence sort of regime, where maybe 5% of the country owns all the land. I mean, that's pretty much happening even now, but now it's happening in a different form. So I think the argument kind of, unpacks in its own way. If you're willing to accept the logic for reservations in universities, then I think this is only a fair accommodation being made for the UPSC exam. But again, that's my subjective view. I mean, you're more than free to disagree and say that you have a different set of reasons, right?
Thank you so much, Professor Chauhan. Thank you to all the students for participating in session 2 of the workshop. I also want to thank Ms. Usha as well as Professor Ranjit Ibrahim for making this happen. I think we can close the session for now, and we will meet you again for session 3, which will take place at 9 p.m. tonight. Thank you all. Thank you, Professor.